Good afternoon, and welcome to the Appellate Division First Department. There's almost 6 hours of requested argument time, which would keep us here till 8 o'clock, and I can assure you, the members of the bench who are at the end of the calendar will not appreciate that. That being said, please ask for only the time that you need, not the time that you want, understanding that we are fully familiar with the briefs, the record, oftentimes more than you wish we were. So, when I cut your time, please understand that if my colleagues have additional questions, I will allow the clock to continue, okay? So you get as much time as your argument warrants. That being said, let's begin with the call of the calendar. People versus Gil Maldonado.
Appellate request 5 and 2, Your Honor.
Respondent request 5.
Okay, 4 and 1 and 5. Rosenthal and Roosevelt Island Operating Corp.
Request 5 and 2, Your Honor.
Okay,
The state respondents request 5 minutes, Your Honor.
We have respondent request 3 minutes, Your Honor.
okay, 5 and 2, 3 and 3. B. Raymond versus Kenneth M. is submitted. Richard Ventura and Dizib Sabio, those cases are going to be heard together. Okay, you have no appellant here. Do you still wish to be heard? Okay, I'm going to give you 3. It's a simple case. Okay? People versus Raymond Watt.
Appellate request 3 and 1, Your Honor.
Okay. 3 and 1 and 3. Thank you. Isaac versus 135 West 52nd Street.
Request 5 and 2, Your Honor.
Okay. 5 and 2 and 5. Capitas Servicing versus Point Blank is submitted. People versus Ronald Hinton. How much? 5 and 2. Okay. Okay. 5 and 1 and 5. Island Stars versus Bucaria.
Appellant request
5 and? You want rebuttal time? Okay. Okay. 5 and 1 and 5. Wells Fargo versus Biderman, and we have received your additional citations.
Good afternoon, Your Honor. Appellant Wells Fargo, request 5 and 3.
Okay. 5 and 2 and 6. PJD Corporate versus Henry George School.
Good afternoon. The appellant requests 5 and 3.
Okay. 5 and 2 and 5. 161 Ludlow Food versus LES Dwellers.
Good afternoon, Your Honor. Appellant request 5 and 2, please. Appellate request 5.
5 and 2 and 5. Tishman versus Himmel and Mergenkoff and City of New York.
Good afternoon, Your Honors. Appellant request 8 and 3, please. Appellant request 4.
Okay. 5 and 2 and 4. People versus Anderson Worrell.
Appellant request 6 and 2, Your Honor.
6 and 1. And how much did you ask for? 6 and 1 and 4. Okay, People versus, no, Figueroa versus City of New York. Okay. 5 and 1 and 2. And Condo versus Condo is submitted. First case on the calendar, People versus Gil Maldonado. Give me 1 minute. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Sarah Chaudhry, and I'm counsel for Appellant Gil Maldonado.
So at issue before this court is whether the Court of Appeals decision in People v. Tolentino forecloses seeking suppression of police observations that directly flow from an illegal vehicle stop. The Tolentino court did not address police observations. Rather, it was narrowly limited to determining that neither a defendant's identity.
What made this stop illegal? Why don't we start there, since everything you're arguing is premised on that conclusion?
Right, so Mr. Maldonado sought a suppression hearing, and the court summarily denied his suppression hearing. And he set forth numerous factual disputes with respect to the legality of the stop. However, the court's decision to deny Mr. Maldonado a suppression hearing was not predicated on a deficiency of fact.
I thought that the court granted a Huntley-Dunaway hearing, but denied the motion to suppress the police officer's observations of him. Frankly, a motion I have never seen in all my years doing criminal cases, that the res gestae of a police officer's observation underlying an arrest cannot be testified to.
So it's not the fact of the arrest that we're seeking to
But
suppress.
you move to suppress the police officer's observations, meaning what he saw.
We moved to suppress, yes, what he saw after the stop had happened. And that's because
So what were his observations?
the observations would have been and were the police officer observing Mr. Maldonado operating a vehicle. Mr. Maldonado was charged with and pled guilty to.
Driving a vehicle with a covered license plate?
No, so with respect to the covered license plate, the claim that the prosecution makes now is not one that they had raised below. So this court can't even address that.
Let me just see if I understand. Your argument is that in him operating a motor vehicle, your motion was to suppress the police officer observing him operate that motor vehicle?
That's correct, Your Honor. And that's because in order to make out a charge of VTL 511, there are two key pieces of evidence. One is the police officers or some other witnesses' observations of the defendant operating a vehicle. The other would be something like the DMV records at issue here, because you need to show that someone is operating a vehicle with knowledge of the suspension of their license. Now, absent a police officer's observations of Mr. Maldonado operating the vehicle, you would not be able to make out that claim. And those
So
observations.
what, in your view, did the police officer do wrong in making this observation?
The observations themselves, they were,
If a
they
police
only
officer is standing on the corner and sees a car drive by, you're saying that's suppressible?
it's not the officer seeing the car drive by, but it's the ability for the officer to identify my client as the individual who was driving that car. Absent the stop, the officer would
So
not
he
have.
sees someone in the car. He's now able to identify that person. Is that what you're saying is suppressible?
What's suppressible is the police officer's ability to go to court and testify, as you would have to make out this claim, that he saw my client operating.
In a car?
Yes.
In a car?
Yes.
Let me ask you this question, because I'm just wondering how do we find your position in the law? So your position would then have us find everywhere that people's, not even just police officers, but observations in general cannot be used to prove elements of crimes?
Well, Your Honor, there's actually, it's very well established under the Fourth Amendment that observations are considered intangible evidence that, and if they flow from illegal governmental activity.
But I still haven't heard what the illegal activity is, right? You cannot, it seems to me that you're saying because what he did after the stop is illegal, his observations before the stop should be suppressed.
No, what we're saying is that Mr. Maldonado was entitled to have a suppression hearing where the issue of the legality of the stop would have come into play. The court.
But you were granted a Huntley-Dunaway, and a Dunaway hearing tests whether the officer had probable cause in the first instance.
Right.
So that was granted and would have been tested had your client gone forward with the hearing.
Well, Your Honor, the subject of the Huntley-Dunaway would have only been the purported statement that my client had made. The lower court's decision expressly, implies and indicates that Tolentino itself.
The people opposed the Dunaway portion and the court granted it anyway, right?
Right, but we still would.
And the Dunaway portion, like my colleague said, would include those facts as to what led up to the stop that led to that particular statement being taken.
Well, even if, say we even had the hearing and we went forward with it, the court had already determined that as a matter of law, People v. Tolentino foreclosed the suppression of the police observations. And that's what's at issue here. And again, there's
You'll have time on rebuttal, but I continue to say, I know of no instance when the res gestae of a crime can be the observations that equal the res gestae of a crime can be suppressed. Either the evidence that flow from the fruit of that can be suppressed, but not the observations themselves. And I will allow you time on rebuttal to respond to that.
May it please the court, Jonathan Sklar for the people.
Am I missing something?
Your Honor, you're not missing anything. In fact, there are 3 bases on which you can affirm this
Well,
suppression ruling.
the defense counsel started saying that you're relying on a ground on appeal that you hadn't raised below about the covered license plate.
Sure. So first, it's inaccurate because the supporting deposition here laid out that Mr. Maldonado was stopped for an illegal plate cover, but that's really of no moment because defendant below sought to suppress evidence that is simply not suppressible. Under CPL 71063A, if a defendant does not allege a legal basis for the suppression hearing, the court may deny it. The court properly exercised its discretion here for 3 reasons. 1, the Court of Appeals in Tolentino held that identity-related evidence, which this clearly is not suppressible. 2nd, in People v. Young, the Court of Appeals held, as Your Honor mentioned, that officers may testify to the circumstances surrounding the arrest, and certainly pre-stop observations, which this is never suppressible. And 3rd, defendant had no reasonable expectation of privacy on a public roadway, as the Court of Appeals held in People v. Bushy. And if Your Honors have no questions, we ask that you affirm. Thank you.
Thank you. I'm going to give you an extra minute.
Okay. So, Your Honors, I wanted to bring up, I think it might be, through analogy, I wanted to talk about People v. Rossi, which I've cited to in my brief, where the court there determined that, so I'll give you a little bit of the backdrop. There was, police officers were investigating an illegal gambling scheme. The defendant was arrested illegally, and post that illegal arrest, the officers saw the defendant put on a jacket where the alleged gambling scheme was occurring. And it was determined that because this was the product of an illegal arrest, the observations themselves had to be suppressed, and that could not be presented as evidence in the case against the defendant.
Where was the illegal arrest? We keep going back to A. Where is the illegality?
So the illegality, first and foremost, would have been parsed through, like at the suppression hearing. So just a conclusory assertion.
No. Why don't you tell us?
You have to have a theory. So are you saying that someone who drives in New York State with a license that's not visible to the police is not a basis for a proper stop?
Your Honor,
I need you to answer that
yes,
question.
I'm going to answer it. That is the prosecution's assertion, and that assertion was...
So what I'm asking you is, are you saying that it's your argument that it is not illegal and therefore not a basis for a proper stop if a vehicle is seen driving without a license plate?
Okay, so if I can, I have a few arguments that I'd like to say in response to that. So first is that the prosecution did not preserve that argument, did not raise that argument, did not cite to it in its papers. 2, the mere fact that they are asserting that that was the basis of the stop is something that should have been explored in a suppression hearing. This is not a situation where the court said, you did not properly raise a factual dispute. It said, as a matter of law, People v. Tolentino forecloses the suppression of police observations that flow from an illegal stop. And that's notwithstanding the fact that there's well-established Fourth Amendment jurisprudence like People v. Rossi and People v. Gethers that say the intangible evidence, such as observations, can be suppressed.
Okay, I'm going to note that you didn't answer my question, but I thank you for your argument.
Thank you.
Rosenthal versus Roosevelt Island Operating.
Good afternoon.
You may
Good to go?
proceed.
Thank you. Good afternoon, Your Honors. Stephen Storch of Storch Byrne for the appellant Susan Rosenthal. Your Honor, we have not found a single decision, and the other side hasn't cited any decision, where collateral estoppel was applied in a situation such as exists here.
So, counsel, I must say, given the fact that we issued a decision previously in this matter involving the same parties and the same allegations, where we found that the termination of the plaintiff was based on legitimate, non-discriminatory reasons, how is it that you're back here again?
Thank you, Your Honor, for that question, because there are several reasons why. First of all, what the court found in its decision, if I may, it said the findings of respondent's investigation constitute legitimate, non-discriminatory reason for a termination and serve to defeat the claims of discrimination and racial animus raised in this petition. That disposes of the second prong of the McDonnell-Douglas test. In a discrimination case, there are three prongs. One is showing that you're in a protected group, and Ms. Rosenthal showed that. Second, it then turns to the employer to show that there was some basis, some rational basis for the decision to terminate. If the employer satisfies that second prong, you don't have a complete determination on discrimination until you turn to the third prong, which is whether or not the plaintiff can show that there was a racial motivation or that a racial motivation was a factor in the termination.
I don't understand you. Are you appealing our previous decision?
Not at all. We're not
I don't get the distinction, and you know the two of us were on that panel,
I understand that, and I'm not appealing it.
including me.
we're not appealing that, we're not contesting that. All this decision found was the first two prongs of McDonnell-Douglas. The third prong of McDonnell-Douglas, whether or not the employee can come forward and show that it was pretext, that the basis for the termination for a pretext was never addressed. And in fact, and it wasn't addressed in your opinion.
Counsel, what does serve to defeat the claims of discrimination and racial animus mean, if not that?
It means that when we're saying that there was not a rational basis, the court said, this is an at-will employee, and therefore I'm finding that because there was a report, that it wasn't irrational for the state to terminate Ms. Rosenthal. What he went on to say was, but there may have been another motivation as to why there was this termination. He expressly says, I'm not deciding that. That needs discovery. That's something that needs a full factual record. And in fact, I'm denying discovery in this case, and I'm sending you to your plenary action so that you can have a full and complete and fair hearing.
So the decision that was rendered by us, that was issued by us a year ago,
Yes.
only had 3 sentences in it. The determination to terminate petitioner's employment was not arbitrary and capricious. It was in Article 78, right? The findings of respondent's investigation constitute legitimate, non-discriminatory reasons for her termination and serve to defeat the claims of discrimination and racial animus raised in the petition. And then the last sentence is, since we find that the court properly denied the petitioner's request for consolidation is moot. Did you ask for re-argument here? Did you say that we left something out?
No, because you didn't. And we've cited in our brief numerous cases that say in Article 78, where there's a finding that it was not arbitrary and capricious, does not preclude a discrimination complaint. There was no reason to ask for rehearing. All that was addressed in this was that it was not arbitrary and capricious because there was a complaint.
How about in the matter of Khan versus New York City Health and Hospital Corp.? It's a appellate division case, 144 AD 3D 600, which held that collateral estoppel can be based on a prior Article 78 holding.
Thank you, Your Honor. For Khan, and I'd also add in, there was another appellate division in this division, Parker versus Flaubert.
You want to address the case I cited first?
Yes, I will. And the reason it's distinguishable is this. In the matter of Khan, the court expressly made factual determinations on the question of whether there was discrimination.
So did we.
No, you did not. There was no record to make that add-on.
Okay, you'll have time on rebuttal.
May it please the court, Stephen Yanni for the state respondents. This court's decision in the Article 78 appeal bars plaintiffs' claims in this action. The court held that the findings of respondents' investigation are legitimate, non-discriminatory reasons for her termination, and critically serve to defeat the claims of discrimination. Now, my friend argues that this somehow left open the question as to whether there may have been pretext, but this court didn't say that the state has presented a rational basis for the determination, and now the burden shifts back to the plaintiff. The court said the claims are defeated. If it had held otherwise, this would have had to go back to the Article 78 court, but this court denied the petition on the merits, and for that reason, the claims can't proceed.
Did we affirm the trial court's decision in the Article 78?
Yes, this court affirmed the denial of the petition.
Okay, and wasn't part of the decision that was affirmed an observation or a direction by the judge that the dismissal was without prejudice? And what would the meaning of that be if there wasn't contemplation for a further plenary action?
Well, I think first and foremost, this court's decision would control. So I don't think we look to the Article 78 trial court's decision to determine the preclusive effect. I think we look to this court's decision. But even so, in the Court of Appeals decision in Parker, there was a very similar circumstance where the trial court had said, I'm dismissing this without prejudice to bring a plenary action. Yet the Court of Appeals held in similar circumstances that collateral estoppel still applied. And Khan is similarly on point and involves similar facts. And of course, we also argue in our brief that the complaint nonetheless fails to state a discrimination claim because there's no plausible allegations of animus here. Plaintiff only points to these bare allegations that she was terminated on Juneteenth, where it's undisputed that an investigation that was conducted the week before concluded on the 17th when the decision was made to fire her, and she was informed of that 2 days later. There's no allegation of how this 2-day delay would indicate that the initial decision to fire her was in any way discriminatory, and in fact, that's not supported in light of the investigation's findings of truly egregious behavior here and plaintiff's repeated admissions that she uses salty and ribald language in the workplace. So for all these reasons, we'd ask the court to affirm. Thank you.
Thank you.
Good afternoon, Your Honor. May it please the court, this is Bushra Kandayoglu. I'm here to introduce the Pro Hac Vice attorney, Ms. Holly Rogers from the law firm of Milliken Porter. She is on the papers to argue the case.
Thank you. Your application is granted, but I will note that New York has over 100,000 lawyers. That being said, welcome.
Excuse me, what was the name of the law firm?
Milliken Porter, Your Honor.
Amelia and Porter?
Milick, M-E-L-I-C-K. May it please the court, Holly Rogers for respondent, Roosevelt Island Operating Corporation, who I will refer to as RIOC. The trial court correctly applied collateral estoppel here. And as we've heard, the petitioner would have the court believe that motive and pretext were not dealt with. And we have heard clearly that this court's decision specifically referenced that the plaintiff's claims of discrimination and racial animus were defeated. In addition, the trial court in this plenary matter also decided the issue of pretext and motive. The trial court here recognized that as an employee at will, the petitioner could be terminated for any reason or no reason at all, as long as that reason was not unlawful discrimination. And the court found that the petitioner's misconduct, which was derived through an investigation, was a legitimate non-discriminatory rational basis for the termination. So the Article 78 court found that there was no discriminatory motive.
Based on an irrationality standard.
I'm sorry, can you repeat that?
Based on an irrationality standard as opposed to preponderance standard in a plenary action. Does the different standards of proof make any difference?
I don't think so, Your Honor. The petitioner is relying on the McDonnell-Douglas burden shifting analysis and trying to say that the lower court did not get to the third prong, and I suggest that they did. And the fact that there, allegedly wasn't discovery to get there, I don't think is dispositive. Contrary to the petitioner's assertions, the Article 78 court said in its decision that the petitioner's asserted basis for the termination, which was anti-white racism, which it referred to in the decision, was not the basis for the termination. So we assert that collateral estoppel is the appropriate remedy here in this case. And just quickly also, to the extent that the court disagrees with that and feels that the lower court erred, the decision to dismiss should be affirmed as to REAC for two reasons. First, REAC did not make the decision to terminate the respondent to the extent that, the petitioner, to the extent that the petitioner would like to proceed with the plenary action to prove pretext. That endeavor would have nothing to do with REAC, having not made the decision to terminate. Secondly, the petitioner's claims against REAC are precluded. She's precluded from bringing those claims based on the doctrine of sovereign immunity. Thank you.
You have 2 minutes on rebuttal.
If I may respond, my counsel raised the Parker versus Blauvert case. In Parker versus Blauvert, the court expressly found that there had been a full and fair opportunity to be heard, and that the plaintiff in that case was given every right to present all its facts and evidence. In this case, there can't be that contention. It can't be. Judge Angeron even recognized it hadn't happened. He said, I'm not going to hear it. You're entitled to discovery. Go take discovery in the other action. I want to read from Second Circuit case, which is directly on point and addresses the concern about,
She was heard at the administrative hearing, no?
No, she was not.
She wasn't?
She was not. And if I may, I'm going to go a little off topic here. This is a person's life who has been destroyed, who had dedicated her life to civil rights and other causes. There was a tape that supposedly showed that she had made these horrible statements, and she was never allowed to hear it. She was never presented with that evidence. When Judge Angeron originally ordered it to be produced, the other side refused to. They didn't produce it. And then he made his decision and said, go get the tape in the other action. There is a new action that's now pending in federal court involving REAC. One of the allegations in that action, and it's a matter of public record, is that the person who did that tape is the person who took over Ms. Rosenthal's job, that he personally taped her, and that he then played it to friends and whatnot. We still don't know what's on it, but she was
So,
booted
counsel,
out.
why didn't you appeal our decision?
No reason to. Your decision doesn't preclude what we're saying. As the Second Circuit said in a very similar instance, a prior judgment that an employer had reasonable grounds for firing an employee does not always preclude a separate action challenging that decision as discriminatory. A finding that a decision to terminate was supported by substantial evidence, essentially that a finding was rational, does not lead inexorably to the conclusion that the impermissible criteria of improper motive was not a motivating factor. And that's what's the problem here. We don't seek to overturn your decision. We accept your decision. We failed in the Article 78. They came forward and said, oh, we have this report. It was rational for us to rely on the report. Now we have to get to the underlying facts, as Judge Angeron said, and was there another motivating factor? And what comes out is, it appears there was a motivating factor. The circumstances
So
of
I
these
would just
tapes.
say, lastly, that our language, our decision said that the findings of respondents' investigation serve to defeat the claims of discrimination and racial animus. Racial animus, by definition, would include pretext.
That's not true.
All right.
I'm sorry, Your Honors, but if I may just take 30 seconds here, because
ahead.
this is somebody's life, and she has not had a hearing. She didn't have a hearing at the administrative stage. She didn't have a hearing at the Article 78 stage. And when she brought the action that the Article 78 judge said she should bring, then it got booted saying, no, collateral estoppel, you had your rights. That's just not what happened here. And I asked the court to take a look at that. Thank you.
Thank you. Richard versus Ventura, Dezib versus Sabio.
Good afternoon, Your Honors. May it please the court, my name is Scott Singer, and I represent the plaintiffs' appellants.
Put the mic to you.
Mr. Zeeb, Ms. Zeeb, and Mr. Richard. Supreme Court's decision appears to be based upon the premise that since the livery vehicle that defendant Ventura was driving was rear-ended, Ventura was necessarily free of negligence.
Not just rear-ended. They described it as violently rear-ended.
Well,
And that description kind of flies in the face of this purported negligence of the livery cab driver who was struck violently, and he was supposed to be able to control the vehicle with precision after being violently struck from behind. I mean, that's basically your client's argument.
well, Judge,
That he failed to exercise some form of that he acted negligently in his reaction to being violently struck from behind.
Judge, I think the important factor here is that this is being done without depositions.
Well,
You know,
they were in the car, so they know what happened. They experienced the hit themselves. Discovery wouldn't change what they know about the accident. They felt it. They experienced it. They described it as violent rear end hit.
Well,
Right?
Judge, you know, there's violent and there's violent. I don't know what that means quantitatively. I don't know how strong the
I know
impact
it's not
was.
a tap, it's not a little tap. Violent is not just a little tap in the rear bumper.
Still, I think it's a stretch to rely on that one-word description, you know, when the parties haven't been deposed, and we don't know exactly, we don't even know how long transpired.
But you would agree that Ms. Zeeb did not attribute any post-collision wrongful conduct to the driver, right?
She didn't attribute it to anything. She just said there was an impact,
Yes.
and they collided. But you know, I think it's important to point out that you know, all the descriptions say that the driver lost control of the vehicle. What exactly does that mean? Does that mean he didn't have an instant to respond? He didn't have a chance to put on the brakes? That he didn't have a chance to veer the car in a different direction? We don't know that because we don't know how long transpired between the initial impact and the collision with the guardrail.
But they would know that.
Right.
They were in the car. They would know that.
Well, there was one of the passengers in the car was very specific, that he saw the driver, you know, veering the car in a direction and pushing on the steering wheel and not applying the brakes. I don't know why that doesn't raise a question of fact, and I certainly don't think it justifies the imposition of liability, of non-liability, without an opportunity to at least examine the driver, Mr. Ventura, under oath. Thank you, Your Honor.
Thank you so much. You have a good day.
Thanks.
People versus Raymond Watt. You may proceed.
Good afternoon, Your Honors. May it please the Court, Heidi Botha of the Legal Aid Society, appearing on behalf of Mr. Watts. Despite Justice Jackson's offer of a total of 8 years incarceration, I submit that there's compelling mitigation to ask this court to reduce his sentence by 1 year.
That offer was made over the people's objection, was it not? The people wanted more time.
That's correct, Your Honor, they did.
The people had wanted 12 years, right?
10.
10 and 2 consecutive on the CPW-3.
That's correct, on the air pistol, that's correct. However, I believe Mr. Watts has what I call, and it's actually been supported by documentation, the trifecta of mental health problems and trauma. First, let's begin with his not only suffering from chronic trauma, but also from experiencing compound trauma, which began at the age of 5 years, that light went on fast, 5 years old, through being shuffled through the foster care system, being returned to his parents, who were both drug addicted, to then both.
Let me just try to move this along a bit, because all of those things presumably might have been known to the trial court. The only thing that's really changed is what he experienced inside, when he was incarcerated, he was in solitary confinement.
For 3 years, Your Honor, which also compounded his trauma. And 7 months before these incidents where he was carrying one air pistol and one other weapon, in 7 months, he was a victim, prior to this, he was a victim of an unprovoked attack. And he was hospitalized and had surgery and was found with a compressed skull fracture. So you add that to his intellectual disability. In his mind, he was fearful, and he has the reasoning of a 9 to 10-year-old. Compounded with all this trauma, it was rational for him.
He was arrested in November of 2017 for having
Correct.
a
And in
semi-automatic
April
having a loaded semi-automatic gun with 14 rounds, right?
That's correct, Your Honor.
And he was sitting in a car with 2 other adults and a child. But less than a year later, while out on bail, he menaces a person with an imitation pistol.
Well,
Can
he
you
had
talk-
an imitation pistol
Why
on
don't you-
his waist, Your Honor.
Why don't you wait till I ask you the question?
Oh, sorry.
Of course. What do you say about the 2018 arrest, which occurs within less than a year but involves an imitation pistol?
That still goes to his intellectual and his fear and his intellectual disability, that in his mind, even though he was already facing a charge for having a gun, which he was not accused of menacing anyone with, just having on his person, it was for protection. And he kept saying that every time he got arrested, it's for my protection. It's for my protection, because he had just been a victim himself of an assault.
Thank you.
Thank you.
Good afternoon, Your Honor. Stacey Nadell for the People. Defendant's sentence here was fair and lenient for having a semi-automatic gun in a vehicle with a 2-year-old child, and while
So,
being...
counsel, is it fair for your adversary to say that essentially the people took advantage of somebody with intellectual limitations?
No, Your Honor, I would not say that's fair. In fact, the defendant's sentence was only 1 year above the minimum, and it was over the people's objection, and the sentence was over the people's objection, but it's the judge who imposes the sentence, and the sentencing court noted, Justice Jackson specifically said that the defendant's mitigating circumstances were so compelling that she imposed a sentence under the people's minimum, under the people's
Recommendation.
suggestion, I apologize. And she made it very clear that she was taking into account the mitigating circumstances. The defendant here was facing a maximum of 15 years for criminal possession of a weapon in the second alone, and received the sentence of 8 years plus 5 years PRS in the aggregate. Given the facts of possessing a gun in a car with a 2-year-old and committing another gun crime while out on bail.
Talk about the second one, the 2018 indictment, where the defendant menaces someone with an imitation pistol. Is the fact that it was an imitation pistol dispositive in any way?
Yes, Your Honor. The fact that it was an imitation pistol is not dispositive. It appeared to be a gun, and while the defendant was holding it up to the victim in this case, he said, "What are you looking at? What are you looking at?" So to the extent that the defendant claims that that gun was for his protection, he was affirmatively harassing somebody with it, with no other indication and no facts to the contrary that it was in response to a threat. So with the facts, with the fact that Justice Jackson explicitly considered all of the mitigating circumstances, she was compelled enough to fashion the sentence appropriately. She considered all facts and circumstances before her, and ultimately the sentence was fair and lenient. And if there are no
Does
other...
the record reflect in any way that the defendant was experiencing a bipolar episode? Because I understand that he has a diagnosis of being bipolar and having narcissistic personality disorder. So is there anything in the record that says that this was an episode, that he had a mental breakdown or crisis in 2018 when he menaced somebody with a make-believe gun?
Not to my knowledge, Your Honor. And while those circumstances are compelling, the mental health and the substance abuse, the court did take those into account. Thank you.
If I may just respond to the imitation pistol, he did not hold it up. If I'm fairly positive that the accusatory instrument said he had it in his waist and showed it and said, "What are you looking at?" And I'd like to just take a moment to focus on his reentry. He has his mother, who is now free of drug abuse for many years and would like to help her son. He has his long-term partner who he can live with. He will be supervised for 5 years under post-release supervision as well. So
How much time when is his conditional release date?
1 year, 1 year and 7 months from now, Your Honor.
Thank you.
Thank you for your time.
Isaac versus 135 West 52nd Street.
Good afternoon, Your Honors. May it please the Court, Brian Isaac. I represent the plaintiff appellant.
Ms. Isaac, the plaintiff never made a motion for summary judgment in this case, or did he?
I thought he might, there was some reference to a summary judgment motion.
By defendant.
Yes.
I did not find one by the plaintiff.
It's
I
not
didn't
in.
miss it.
No, I don't think you missed it.
So I want to ask you about a couple of items of testimony during the course of the trial. Fee of New Line testifies, and I believe this testimony comes in without objection on page A688. Sir, is it your understanding that safety railings are not required on scaffolds less than 6 feet? Is that correct? And his answer is sure, yes. And then Mr. Costa testifies, and he says, as far as the scaffold having wheels, it is your understanding how tall was the scaffold? He says it's about 2 feet. Then now that's 3 feet a little later on the page A632. If you had a scaffold this high off the ground as a foreman, as a safety guy, is it your understanding that you do need to have safety rails? I think it meant to say does not need to have, although it's not written that way. His answer is yes. Who told you that? By code, you only need a guardrail over 7 feet. So your understanding is if anything is under 7 feet, your workers can go up there without any railings around the side. Is that your understanding? Yes. So that also comes in without objection. How did that become? First of all, typically, does the issue of whether a scaffold meets the requirements of 241, does that typically go to a jury? How did that happen in this case?
Well, I don't know how it happened, but my position.
I understand you didn't try the case.
My position is it's irrelevant. Look, juries determine facts, judges determine law. But my response to you is, as a matter of law, in this case, you needed to have some type of protection because that's what the cases say. I can say that I'm an appellate division judge. I'm still just Brian Isaac, a lawyer. So the fact that
And the statute says, not just the cases, the statute requires.
100%. And we cited to the cases going back to Megna against Tishman Construction that 2-foot falls require protection. But let's talk about just the facts here, because Judge Friedman, you brought up some facts. Let me talk about some other facts. My client is using this gigantic Hilti gun that usually takes 2 people to use, but he's a strong guy. He does it with 1. He's doing core drilling. You saw the photos of the scaffold by himself. His testimony, 500 to 505 and 543, is he's putting it in, the lever shakes. 543, he says the scaffold shakes. He's provided with no rail protection at all, and he takes a header off the back. And the defense is, well, he said in some medical records that also Judge Friedman probably shouldn't have been admitted. I stepped back. I did Cuevas, I did Lopez, I did Ram. They're not inconsistent. When you go to a doctor, you don't have to talk about the labor law, you talk about your injuries. And if you look at 3 cases, Vergara, Orellana, and I think the Lynn case, it covers everything. Every one of the defendant's arguments were rejected there. It doesn't matter if he says he stepped off. If the causative effect of the step is movement or a violation of the labor law, that's a violation. In Orellana, There were 4 different versions of the accident. You said it didn't matter because the ladder was defective. And one of the claims there was that the ladder didn't violate the code. But let me, if I can, because I know you know the cases, let me read to you what you said in Lynn. It's a recent case, 193 AD 3D 650. You said that in that case, 3 perfect quotes. This is not a case where an issue of fact is raised as to whether plaintiff simply lost his balance or footing while working on a properly secured ladder. That's this case. The interrogatory, the first interrogatory, is a nightmare. It's horrible for the plaintiff, but it actually turned out to be good for me because I ended up winning. But this is the interrogatory. Did the accident happen substantially in the manner claimed by plaintiff? If you answer no, the instruction is stop, defendant wins. That's on 1102. They agreed with what my client said. That's the purpose for the interrogatory. I can't lose on 240 when that happens. The second question, I understand, is probably redundant, but I don't lose on that.
You know, the trouble with that question is, and it seems like an odd question to have given a jury in a case such as this, is that the plaintiff's version of exactly what happened, even looking at it in the best light for your position, is not consistent. I mean, at one point he's falling, at one point he's stepping off. So what did the answer to this, what does yes to this question mean?
Judge, you're not going to hear disagree with me.
I know it gets you past.
Yeah, it sure does.
To go on, but it's like, this is a question which, what does this answer mean?
And I would ask you to answer to frame your answer in light of what Vergara said in 2005. It does not matter whether the plaintiff's fall was the result of the scaffoldings falling over or its tipping, or whether the plaintiff was falling down. So how do you answer these questions?
Well, I agree. I think Vergara is great for me. I don't think it matters at all. We have 4, my light's on, is it okay? We have 4, from what I can see, 4 separate label law violations. We have a scaffold, it is a scaffold with no railings at all. Those side things are just elevation devices. We have an external force by this giant Hilti gun coming back. We have movement of the ladder, and we have the plaintiff being impacted by it. That's 4 violations. This court has held, what's in John against?
Movement of the ladder, did you?
I mean, I'm sorry, movement of the scaffold, I'm sorry. This court has held, I think, St. John against Baharastani, it's 281 AD 2nd, that you could have 5 versions of the accident if the plaintiff wins on every version. That's it. There's a label of violation. That's what happened here.
Thank you.
I won't go over my time. Thanks for listening to me.
If it pleases the court, Richard Calabrese with Cascone and Klepfeld for the respondent.
So let me ask you about this testimony at page A651 of the record by Mr. Costa on cross-examination, which also comes in without objection. Question that's fine, I'll withdraw it. Would you agree, sir, that if you put that railing up, it wouldn't have made the job more dangerous for the workers, it would make it safer? Answer, maybe it would be in the way of drilling. Question, so did you make the determination in order to make it easy to drill not to put the safety railing up? Is that what you are testifying to? Answer, I don't recall. Question, well, would you agree, even with the widest scaffold that is shown in this photograph, that a safety railing could have been put up and you could have easily used a hilt drill, kept the workers safe, and be able to drill up to the top? Yes? Answer, it's an option. We could put the guardrail in, yes. Question, it was an option, you decided not to do that. Answer, it's not my decision. In the face of that testimony, how does that testimony permit your position to stand under Labor Law 241?
It permits it to stand, Your Honor, in that it was a determination made that this scaffold that was being used at the time of accident and under the circumstances of the work being performed, that railings were not required.
What exception under 240 sub 1 permits the non-use of a guardrail without providing an alternative safety device when a worker is engaged in work that constitutes 240 sub 1 work? What exception is there that would say, well, in this circumstance, you don't have to follow the law?
Well, Judge, as you're aware, 240 does not require a railing.
240 requires Oh, we're quite familiar
I
with
know the
240.
court is very familiar, as are we. Your Honor.
Very familiar. And so the statutory language is pretty clear.
Shall be constructed, placed, or operated to provide proper protection. The
Right,
jury
and that
found-
obviously didn't happen here, so.
Well, that's if you believe Mr. Isaac. Now,
Well,
what
no,
did
well,
Mr. Isaac
apparently the
testify to?
jury believed Mr. Isaac.
that's the
And the
problem.
special interrogatory told us that, so that argument is not available to you.
With all due respect, Your Honor, I believe it is because Mr. Isaac was all over the place. And Mr. Isaac,
Counsel, but at the end of the day, you can't say we should accept the jury's verdict, but ignore their answer to, we believe that it happened just the way the plaintiff said so.
we're not asking the court to ignore anything.
You should just clarify.
The
when you
verdict
say
is
that
not
Mr.
inconsistent.
Isaac was all
Sorry,
over
Your
the place, that you don't mean this Mr. Isaac.
No, not this Mr. Isaac.
Yeah, they,
We
it's,
know-
it's
I know
weird.
that.
You guys
fact,
have
when the
the
case
same
came in-
name.
When the case came in, we were confused.
I know who you're talking
But-
about.
Sorry, Your Honor. But basically, Mr. Isaac, as the court has seen, gave many versions.
Your ultimate fallback position on this case to try to support this verdict, correct me if I'm wrong, at bottom, your position is that Mr. Isaac testified that he stepped off. And if he stepped off, you're not responsible for that. And the counter-argument to that, and if you agree with what I've just said, but how do you address the counter-argument that he's pushed back because of the drilling, so whether he stepped off or fell off doesn't really matter. You can be liable even with the step off because the step off was caused by the pushback or the kickback from the drilling.
Easily, Your Honor, because it was fettered out through the trial that that's physically impossible. This drill doesn't kick back. It's bolted to the wall. It doesn't fall off the wall. They try and advance at trial and here before this court that he's so strong and tough and mighty he could do this drilling by himself.
Well, it usually is done by two people, right? That is what your people testified to.
The drilling is usually done in a team of two.
Right.
People to lift this very heavy drill and bolt it to the wall, and then really just one person to man the lever. My 8-year-old daughter could man the lever. It's not difficult. It's not hard. The drill is self-pressurizing.
Okay.
It just takes somebody to push it back. Mr. Isaac never said at his deposition that he got pushed back and fell.
How do you get around Bland? Bland says that 241 applies irrespective of whether, irrespective of scaffold height and irrespective of whether a guardrail is required by the industrial code. So here, defense counsel hammered at the jury again and again and again in the opening, during the course of trial, and in summation that a guardrail was not required by the industrial code. Yet here, Bland says, that's not how it works. 241 applies irrespective of scaffold height and irrespective of whether a guardrail is required. You're saying, so what to Bland and so what to Vergara, or are you saying something different?
I'm saying something different, Your Honor, if I may go over my time just
Yes,
to retort.
she asked the question, like I
Thank you.
said.
Land supports the proposition that railings are required under the circumstances. We agree and concede that there is no litmus test at which a railing is required, but the evidence taken out at trial was that this particular 2-foot-high platform, of which there was a picture and which was authenticated, did not require one. And in fact, a railing on that could have potentially made the operation they were doing more dangerous.
So if you made that judgment, then aren't you subject to liability in case you were wrong?
I'm sorry?
If you made the judgment that a guardrail was not required, then aren't you subject to liability if in fact your judgment was wrong? Here, someone got injured. Here, someone was injured. And looking at the photographs of the scaffold, I mean, there's like a billion different ways to construct a scaffold to address whatever concerns there were about impeding the movement of the drill or whatever. But here you had a situation where the plaintiff testified that somebody previous to him had actually fallen off the platform as well, the scaffold as well. So how do you get around that?
If you want to believe him, I submit to you, he was not believable, man.
This is the right picture, right?
Correct, Your Honor.
The case is not presented to us on this basis, I don't think, so maybe it's not really within the record. But when you look at this, you know, the question you have is that why wasn't the scaffold higher, and then there would be no problem having a guardrail at this lower level?
If I may, if the scaffold was any higher,
Not the platform, the sides. You see these side railings that you affix the boards to? You could have easily added another one here on either end and then put guardrails on the back
that's not
so that he would not have fallen backwards off the scaffold.
well. One, that's not how those types of scaffolds work.
Those scaffolds can be erected, as my colleague said, in any way. They can be retrofitted to provide the best possible safety for workers at a given site in a given workspace.
Understood, Your Honor. I think simply put, plaintiff advanced so many, we're all assuming that a jury believed that he.
They did. We have a jury.
I don't
You know,
think they did.
I really counsel
Yes.
the worst
The word is
position you
yes.
have. The worst position that you have here is that the judge gave you that first interrogatory, and I suspect that in hindsight maybe it was a mistake to ask for that question, because that question tells us that the jury believed the plaintiff's story.
Which was advanced many different ways.
That's okay, but they believed
Scaffold-
it nonetheless. And we
stepping
have
is-
your brief.
Thank you, Your Honor.
One further question. How did the case come to be tried? Is the jury deciding whether this scaffold complies with 241? Isn't that a determination typically made by the court?
So thank you for the question, Your Honor. And your first question to this, Mr. Isaac, was why didn't you move for 240 in some? If
Counsel,
they-
answer his question, please, because you're over time.
Sorry. In short, there was such a question of fact. We moved for 240. There was such a question of fact because at deposition he said, I fell 5 feet from a scaffold to my bilateral knees. And then at trial, he said, I stepped out, I stepped back, I fell, and the scaffold could have been anywhere from 2 to 3, 4, 5, maybe 6 feet. So the jury believed simply that he got hurt at work, as opposed to espoused by defense counsel at an opening that he potentially hurt himself walking down the stairs.
But the question wasn't, did the plaintiff get hurt at work? The question was, do you believe the plaintiff accident happened as he said it did?
Substantially similar.
Okay.
Which we don't know.
That's okay.
We don't know
Thank
what the
you.
jury believed. Thank you.
So I'm going to be brief. I just want to point out to the court, although I see you, as usual, you know the case better than we do. Even at the trial, the plaintiff used the term stepped, right? That was the way he saw it. It's at 500, paragraph, line 20. Okay, from what I can remember, I was standing, and I'm left-handed, so I was standing on the scaffold and was using the lever, and it jerked. Lever can jerk if it's that big. I don't care how it's affixed, and no 6-year-old can pick this up because I can't pick it up. Next sentence. When it jerked, I went out of reaction. I went to step down. So meaning he's going backwards. I came down and I fell. And in Pin, you said this. Plaintiff's statement to his supervisor that he fell because he lost his balance is consistent with his more detailed testimony regarding how he lost his balance and fell from the ladder after it moved.
Didn't the plaintiff also testify, record 550, I stepped off, stepped down, I stepped and fell off the scaffold.
Yes, but he also said at 5:02, and I'm not going to go over my time, lines 2 through 9, okay? Can I just read it? So it'll be easier. The scaffold that I had, it had ladders on the side, and I would climb off on the scaffold. On each side, they had little ladders like to climb up. Question. Again, if someone stepped off the scaffold without using the ladder, that would be rather stupid. His answer, crazy. Question, did you do that, sir? Answer, no, I did not, sir. So he's using language that isn't great for a lawyer. It's not great for a judge, but he's not an appellate division judge, and he's not a lawyer. He's a construction worker.
Is there any version of the accident that the plaintiff testified to at trial that would not support 240 liability?
With respect to the way the jury answered the interrogatory, no. And under Knobloch, under Upfront Industries, and under Bickler against Eli Lilly, I have to assess this verdict in light of the charge in the jury interrogatory, and so does the court. Thanks for
Thank you.
listening to me.
Thank you. People versus Ronald Hinton. You may proceed.
Good afternoon, Your Honors. I'm Nick Justice for the Legal Aid Society on behalf of Mr. Hinton. Sentencing Mr. Hinton to the maximum term of probation for possession of a forged instrument was excessive. When Mr. Hinton faced the sentencing court at 54 years old, he had been suffering from an addiction to crack cocaine for over 30 years. That disease motivated both this crime and the overwhelming majority of his previous criminal conduct. After spending most of his 20s and 30s in prison, Mr. Hinton was able to find residence and full-time employment for the first time in his life, after which his contacts with the criminal justice system dropped significantly. In this case, Mr. Hinton pled guilty to the top count before the court to get an early start on his probation and treatment for...
He got a very good deal. Can we agree on that? I mean, he resolved 3 separate incidents, attempting to use a forged license in 3 separate banks. Had he attempted to fight these cases throughout, he could have been hit with consecutive time on these cases. So 5 years probation was like a gift with a big red bow on it. And so I say that to you, not at all to be disrespectful, but we also don't want to undercut a court that went out of its way, it seems to me, to really give your client a shot. In light of his history and all of his prior felony convictions, I thought the judge really went out of its way to afford your client a fair disposition. Am I wrong?
I disagree with that, Your Honor. The maximum term of probation in this case was excessive.
Yes, but had he gone to trial, he could have done 1 to 3 to 2 1/3, and at least 3 of those could have been consecutive.
And I would add that this plea was taken against the people wanted a year.
It's true that the judge found that incarceration was not appropriate in a case like this, and I concede that because of the way this crime could have been partitioned out, he was subjected to consecutive sentences at trial. But that is a reason why this court should maintain the ability to review plea agreements. I would remind the court that this was one series of
You're talking about someone, this is his 8th felony conviction?
9th.
It's their 8th felony conviction, Your Honor. 7 of those felony convictions came 16 years ago, at least 16 years ago.
That's why he got probation.
I understand that, Your Honor, but also the overwhelming majority of those felony convictions and his criminal conduct were possessory or were drug-related offenses or larcenous offenses that are very typical of someone who's struggling from a long-term drug addiction.
So the problem here is that the defendant went from one bank to the other within the course of 2 hours, I think, with the forged documents. And your argument is that, correct me if I'm wrong, that we shouldn't be looking at the aggregate exposure, but rather looking at the exposure that he would have faced if it had been just one bank.
Your Honor, I'm arguing that you should be looking at the harm intended from his conduct when deciding whether or not the sentence should be excessive. And the fact that he failed at 2 banks immediately before the bank that ultimately called the police, that does not indicate a harm that's 3 times as great as if he had simply completed the intended crime in the first instance. But as the prosecutor had pointed out in their brief, that's precisely what he was subjected to. So it should not be held against him when he understandably accepts the maximum term of probation as an alternative.
His exposure was 7 to 21, indeterminate?
Potentially, Your Honor, if the court were to run those sentences consecutively, but again, Your Honor, that would have been to multiply one attempted offense as if it were 3 completed offenses. And it's precisely those circumstances and the fact that a district attorney has that type of discretion to bring those penalties for this type of conduct, which is why this court should feel comfortable reviewing plea agreements and reducing the sentences that stem therefrom.
Counsel, he's been on probation approximately 4 years now without incident. Would it be within the Department of Probation's purview to discharge him early if they saw fit?
They have the authority to do that, Your Honor, but that does not absolve this court of its authority and its responsibility to review his sentence for excessiveness and address it in the first instance. He has been doing well on probation, but our submission to this court is that the sentence was excessive from the outset.
Thank you.
Good afternoon, Your Honors, and may it please the court. Bridget White for the people. First, defendant's excessive sentence claim is foreclosed by his valid waiver of appeal. But in any event, defendant's sentence was fair and appropriate. First, the fact that defendant agreed to the sentence, though not dispositive, is evidence of its fairness. This defendant had previously rejected offers and was prepared to go to trial. So the fact that he accepted the sentence here indicates that it was fair. Defendant notes his employment as a mitigating factor. The fact that defendant received probation instead of jail was what allowed him to continue with that employment. Defendant also avoided 11 felony convictions. He was charged with 12 felonies here. And as Your Honors have noted, he had fairly significant jail time exposure here. If the court had chose to run those sentences consecutively, he could have been in for a max of 21 years.
The appeal waiver was valid. Can we consider his application, his request that we reduce his sentence?
I believe you can in the interest of justice, but we would ask that you uphold the waiver because it was made knowingly, voluntarily, and intelligently.
So looking at the papers, your adversaries, or rather I should say the defendant basically says, look, I've been a crack addict for a very long time. I fell off the wagon. Why don't you give me a chance? What's the problem with that?
Well, I think the court did give him a chance in the sense that despite defendant having, although not the most recent history, he did have fairly significant criminal history. The judge undercut the people's recommendation of a year in jail. I believe this sentence was designed to give him a chance to continue to get help and to continue his employment. And I think the judge made that clear when she explained on the record the last felony was a long time ago, and defense counsel was asking for this term in order to enable defendant to go to rehab. Further, these factors were before the sentencing court, and as Justice Pittberg mentioned, there are other avenues through which defendant could pursue relief here through the Department of Probation, rather than asking this court to declare the trial court sentence excessive. If Your Honors have no further questions, we would ask that you affirm.
Thank you. You have 1 minute.
Yes, Your Honor, I'd like to just briefly address the appeal waiver. It was invalid for multiple reasons. First, the court miscategorized Mr. Hinton's appellate rights as those automatically forfeited by a guilty plea when it admonished Mr. Hinton in its colloquy, had you gone to trial in this case, a higher court would have had the ability to review decisions of this court. That implication is the opposite of our Court of Appeals admonishment in People v. Thomas, that a trial court must specify that those rights are entirely separate and one is not predicated on the other. Additionally, the court's description of the waiver was unclear. The court basically just told Mr. Hinton that it was the right to have a higher court review decisions at this court. That's significantly under-inclusive. An appellate court obviously can reveal a whole host of errors that have nothing to do with solely a court's decisions, as well as the conduct of both his attorney and the prosecuting attorney. Third, specifically with his respect to this excessive sentence claim, the appeal waiver did not distinguish between a legality of a sentence, which it explicitly told Mr. Hinton he was retaining, and the excessiveness of that sentence. The second and fourth departments have both recognized that a layperson is not going to understand the difference. The cites are in our brief. And with that, we ask that you reduce Mr. Hinton's sentence in the interest of justice.
Thank you so much. Island Stars versus Beccaria. You may proceed.
Good afternoon, Your Honors.
Good afternoon.
Stephen Universe and Ice Univer, appearing on behalf of the appellant, may it please the court. The underlying appeal stems from the court's misapprehension of the relationship between the appellant and the respondent. The underlying court had dismissed the claim before any documentary evidence was exchanged, any depositions, and they used basically a summary judgment standard for a motion to dismiss. The appellant had stated multiple times and pled that the respondent was aware of the circumstances and the reason that the appellant had wired $1 million, and it was not for the debt of the for a third party at the time.
What were those reasons?
The reasons were for an investment in an underlying motion picture that was already out, and the MSP,
So you wired the money to MSP, right?
our client wired the money for MSP.
What specified that that money, and it went to MSP instead of UpSense, right?
Correct.
So, but what specified that this money was specifically as an investment in 2017?
I believe the film was 1917.
1917, I'm sorry, 1917.
Luckily, no movies yet on that. So the Howard Schuster, who is the president of MSP, was CC'd on multiple emails that were between Richard Beccaria and my client and the appellant that stated that the money was going for the investment of a major motion picture. They had the requisite knowledge to understand that that money was going directly for investment purposes and not for paying the debt of UpSense.
And what document, what contract, what agreement would you say we should look to tell us what the terms of that agreement was, and with whom was that document agreed to? Who were the parties to that document, and which document are you relying on for your contention?
So there was no document between MSP and the appellant. The only document there was UpSense and the appellant. The UpSense, they had a document that they were
So
going
how
to.
does that potentially make MSP liable to conversion?
They had the requisite knowledge. They understood and they knew what the money was going for, and it was more of.
Was the agreement with them? Was the agreement with MSP?
No written agreement existed with MSP and the appellant.
Your agreement was with the plaintiffs, correct?
We are the plaintiffs.
I mean,
Sorry, with UpSense.
right.
With a dismissed
You
defendant.
had the agreement with UpSense, correct?
Correct.
Okay, and then UpSense had the agreement with Beccaria and that group?
No, the UpSense is Beccaria.
Okay.
And then the other defendant is MSP. They had an agreement together. So Beccaria and Schuster had an agreement that we were not privy to.
So normally, appellant would have wired the money to UpSense, and then UpSense over with their agreement over to MSP. But instead, he wired the money directly to MSP. Was there anything that said, I'm wiring this to you, to MSP, but remember, it's for 1917. UpSense is aware of it. This is just how we're going to do it in this instance.
Well, UpSense requested us to directly wire it to MSP. MSP was aware that our knowledge was that this was for an investment. However,
the problem is the term aware. Aware how? Was there a writing? I think you've been asked a few times. Was there any writing that directed MSP to funnel this money to the film?
there was no writing that directed MSP to direct the money to the film or to the motion picture studios. However, the MSP was CC'd on emails.
Why did he send it directly to MSP? What was the reasoning behind that?
They had a prior relationship with UpSense that requested us to invest in movies beforehand, and they just requested us to do it.
Was that the practice, that they always sent it straight to the filmmaker, or?
This was only my client's second foray into investing into films. So he was just listening to a friend of his that, or the prior partner in a different motion picture to invest that way.
Was there a financial benefit in sending it to MSP in New York as opposed to sending it to UpSense in Australia?
It was just a request because everything was in Australia. It would have been
Did you do
simpler to
it
do
for
it.
Currency exchange reasons?
No, Your Honor, not from.
So what does it mean in page R17 when it speaks of that?
This was requested by UpSense to do it because if we were going to send it over to Australia.
But R17 speaks of likely because of the currency exchange issues.
Well,
Page 17, it says, most likely because it didn't make sense to wire funds from New York to Australia and then from Australia back to New York, given the fact that each transaction required currency or exchange loss of money.
Right, and this would have not been on us, but this is also something that we were not able to delve into because this was done on a motion to dismiss prior to even any answer.
That part of the record is from the oral argument before the court. Was there anything said, hey, that's not what that was about? Inside that part, that oral argument saying, no, the counsel misspoke, because that was counsel representing those facts. Was there anything saying, well, no, counsel misspoke? Was there any counter to that statement?
Not at the time, Your Honor.
What is the relationship between MSP and UpSense?
Well, from my understanding, they still do business together, and the UpSense
They're independent entities?
They're different independent entities, but from my understanding is that UpSense would invest money into MSP, and then MSP would funnel the money to motion picture studios or anybody that's funding movies, and then they would receive a return. We were purchasing 11.85% of that return.
Okay. You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Mark Fry on behalf of Respondent Major Studio Partners. So counsel is, I think, complaining that he wasn't given a chance by the lower court to fully develop the record, but this is a very detailed complaint that was filed. This was not some sort of bare-bone complaint that needed fleshing out. It's a 31-page complaint, I think 168 separately numbered paragraphs. And the complaint delves into
But it is a 3211 motion. It's not summary judgment.
Yes, it was 3211. But there was enough detail in here concerning the relationship among the parties.
Counsel, just going back to that record 17 where it's suggested that this particular avenue in wiring the money from Levosky to MSP was done for, financial benefit. The next statement made by that particular counsel was that, but we don't know, right? So that's speculative. Why wouldn't discovery resolve, in fact, that part of it?
Well, it was clearly done because of currency exchange. The plaintiff was located in New York State. MSP is located in New York State. UpSense is located in Australia. So even though Mr. Levinsky had his agreement directly with UpSense to wire the fund to UpSense would be a money transfer, and then for UpSense to turn around and send it back to New York is another currency exchange, and each currency exchange affects the amount of the investment.
Do we know by how much it affects the amount of the investment? Do we know? Is that in the record?
I don't know, but it was $1 million.
Would that be solved maybe by discovery?
I'm sorry.
Would that be resolved by discovery? I'm just trying to wonder, should we have discovery maybe to flush out these issues? Because everything seems kind of speculative at this point. We do know that the money went straight to MSP and it wasn't earmarked for anything. But all these other issues, do they matter?
No, it doesn't matter because their claim is that Mr. Beccaria, who was the UpSense agent in the United States, he directed the investor to send the money directly to MSP, and they're claiming that as a result, this money shall now be treated separately and distinct from other investors, and not as investment funds that UpSense supplied, but as investment funds that this individual supplied. And if my client did that, that would have placed my client in breach of its contract with UpSense. It was clear that these funds were being supplied to fund UpSense's agreement with my client to provide funds. So these were not individual funds to be held separately and treated separately. These were to be aggregated with other monies that UpSense would be sending, which would then be bundled and sent on to New Republic Pictures.
Are you saying that MSP had the authority or the ability to delegate relegate or delegate, I don't know which word it is, those funds to whatever monies were owed or yeah, let's say owed by Upsense?
Yes, yes. I,
There were no
my client, my
Yep.
Upsense entered into an agreement with my client that they were going to send $3.5 million in total.
Right.
And my client was going to take that and give it to New Republic Pictures. But they never supplied the $3.5 million. They supplied much less. This was one investment that Mr. Beccaria brought via to MSP.
Does that mean that all the money that was sent was going to be directed towards the picture?
Yes.
So it did have a specific purpose then attached to it, the money?
Yes, but it was sent on behalf of Upsense, who was not a party to this case. That was another ground of our motion to dismiss, that Upsense was a necessary party. The lower court didn't reach that because they dismissed it on other grounds. And again, these are quasi-contract type claims that they're trying to assert, but there are very clear contracts which are set forth in detail in the complaint which govern the relationship among the parties. And in this situation, the remedy is to sue for breach of contract, which they are doing in Los Angeles.
So one of the elements of conversion is that the money has to be subject to an obligation to be treated in a specific manner. You received no directive whatsoever from Mr. Lebowski as to how to direct the money?
No, the money was to be treated pursuant to the contract between MSP and Upsense. And Mr. Levinsky supplied the money on behalf of Upsense.
Thank you.
Thank you.
You have 1 minute.
If I may. I think it was counsel had stated a very good point, was that it was clear what the money was sent for. It was not clear. The MSP was on notice at all times that my client was under the assumption that this money was going directly for a film, not for debt that MSP owed, or that Upsense owed to MSP.
And the notice was contained in what?
It was through his knowledge in emails when MSP was CC'd. When the Howard Schweitzer, I believe, Howard Schuster was CC'd on emails with Mr. Beccaria, knowing that my
Where is
client...
that in the record, please?
It was in the motion to amend the complaint in emails as an exhibit. I don't have the record exact number, but it was in the motion to the amend complaint, which is part of the record, as I believe Exhibit F as well as Exhibit D.
Thank you.
And if I just may, one more. It is vital for us that under...
You may finish your thought. Go ahead.
I apologize. Under Manufacturers Hanover v. Chemical Bank, which was a similar matter where a client sent over money to a third party when they did have the knowledge to do it, and did knowledge that the money was supposed to go to a different matter, still used the matter to pay off a debt, was found that the client should have received the money, and they established a claim for conversion. Thank you, Your Honors.
Thank you. Wells Fargo Bank versus Biderman. You may proceed.
Good afternoon, Your Honors. May it please the Court, Jamie Katz-Sussner with the firm of Sills, Cummins & Gross on behalf of Appellant, Wells Fargo Bank. Your Honors, the reason for this appeal is this action that was dismissed below was an Article 15 proceeding, seeking equitable and ministerial relief of recording a power of attorney that was intended to be recorded at the time of the transaction and was represented to have already been recorded, when it turns out it was not. The trial court did not dismiss the matter on the merits. The trial court engaged in an analysis whereby he concluded that a second foreclosure action was not timely filed and that the debt was stale, so that proceeding with this relief would be moot. The court applied a foreclosure statute of limitations analysis, which he shouldn't have done. He should have applied an Article 15 analysis. Had he done so, he would have concluded that there is no statute of limitations for recording a power of attorney, and that the claim was meritorious. But again, the court never determined whether it was or wasn't
Your
meritorious.
position that whether or not you can still be foreclosing on the mortgage is for another day, although we were handed a decision right before oral argument, which maybe has Supreme Court deciding against you on that, so I suppose that will generate another appeal. But the issue of whether you still have a viable foreclosure action is a battle for another day, and at this point, you have a right to have this power of attorney recorded.
That's exactly right, Your Honor. That's exactly right. But even assuming that the court had reason to delve into whether or not it was a live debt and whether we had any business being before the court in the first place, the court didn't apply the right analysis.
So it's because you claim that the COVID toll keeps your foreclosure action within the statute of limitations.
That's exactly right, Your Honor. If the court had applied CPLR 205 together with the executive orders that Governor Cuomo had entered at the time, there was still another 85 days left when the second foreclosure action was filed.
But anyhow, just to be sure, at the original establishment of this mortgage many years ago,
Yes.
so there's supposed to be a power of attorney recorded from one defendant to the other defendant, authorizing the first defendant to be executing the documents, and there's a representation made that that power of attorney has been recorded. And it turns out that that's a power of attorney authorizing a different entity as the agent, in fact. Is that what happened at that closing?
Substantially similar, Your Honor. It turns out that at the base of the mortgage, when one of the Bidermans signed and affirmed her signature under oath, an insertion was made that it was also being signed pursuant to a sister under a power of attorney with reference to a power of attorney of record. Turns out that that power of attorney had been executed by one in favor of the condo board, and nobody realized that there was another power of attorney that it could have possibly been.
But, I mean, by check-in, would that have been discovered if Wells Fargo had done maybe some due diligence? Would that have been discovered or no?
It could have been discovered.
It should have been discovered. I mean, this is like routine. You have a checklist of documents at every closing. Check, 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 check. I mean, it's like a assembly line of paper at a closing, right?
And
this is one of those items in the checklist. So why should Wells Fargo be relieved of their responsibility to exercise due diligence?
Well, because, Your Honor, both sides had an obligation. And certainly the borrowers had an obligation to be truthful.
If the borrower represents to a mortgagee that there's a valid power of attorney on having been recorded, now, of course, a wise decision may make you check it out, but if you fail to check it out, are you somehow held liable for the inaccuracy which is presented to you, that the power of attorney that's been recorded is a valid power of attorney authorizing this person to sign for someone else? I mean, what is it that you violated by not checking?
I don't debate that it should have been checked, but you have to rely upon all of the parties to the transaction being honest and affirming truth under oath. And if the statement was included on the face of the mortgage, while perhaps double checking should have occurred, I don't
But
believe...
we have foreclosed on plenty of properties where the owners fail to exercise their own due diligence and they lose their property. So shouldn't the same rule apply for everybody?
Well, really the question, Your Honor, it's a more basic question. Once this was discovered that the power of attorney was not recorded as it should have been, perhaps it should have been detected at the time, but it wasn't. Mistakes happen.
Okay.
You know, it's unclear whether it was a mistake or an affirmative
You made no
representation.
misrepresentation.
Correct, Your Honor. I mean, either way, right? Let's say for the sake of argument that it was a mistake on behalf of everybody at the closing table. There was still a statement that was included on that mortgage, and in addition, there was an affidavit that was submitted. And the lender was entitled to rely upon it. And so one way or the other, whether it was a mistake or whether it was deceptive, something more nefarious, either way, the lender relied upon that to its detriment. There's no debate here that this loan is a valid loan. This was a purchase money loan. These two sisters bought this condo with this money. They paid it back for 2 years. They ratified the debt. You don't, under the concept of ratification, the principle of ratification, you don't get to accept the benefit without also accepting the burden. And you don't get to say, haha, I tricked you or you screwed up so I get a free condo. That's not the way equity works. That's not the way this works. They bought a condo. They owe this money. They admit it. There's no denying it, Your Honor.
Thank you.
Equity should compel the relief, Your Honor. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Joseph A. Altman. I represent the Biedermans, respondents in this appeal. What we handed the court was the decision of the Supreme Court on a motion to re-argue, which came down.
Denied re-argument.
It was basically, it was their appeal, which was reviewed again by the same judge, and he denied each and every one of their points. What was clear here to the court, and I'm sure to
It'll generate another appeal here, won't it?
No, it won't, because it's a motion to re-argue.
Denied re-argument, but the underlying decision?
Excuse me?
The underlying decision?
Was a motion to re-argue, and was this decision.
The problem is he reconsiders, there's a lot of things said in this denial of re-argument, which means they have an opportunity to appeal it. So you will be back. But that being said, please give us your arguments on this appeal.
Okay, well, as the court can readily see, there's no misrepresentation except perhaps by the plaintiff. They brought this proceeding as a way to resurrect an action to foreclose on a mortgage which they knew was in fact barred by the statute of limitations. And the court saw it, and when the court looked into this, and we discussed this at length, at oral argument, when we had the oral
So
argument.
there's a separate foreclosure action, is there not, in which that's your defense, that the statute of limitations is pending? And has that been ruled upon?
They ruled that the underlying mortgage was no longer valid because of the 2013 action. 2013 action.
That's what Supreme Court ruled?
Yes.
Has that been appealed?
Has that been appealed? No, that's this one.
This one, yeah.
Okay,
This
so
was a separate action to get that power of attorney recorded, is
Right.
it not? And there's a separate action to foreclose.
Right, but in this decision, in order, the court already ruled with the same parties that that mortgage is no longer valid because it's barred by the statute of limitation. It was a 2013 action. They clearly accelerated it. They should have filed the action in 2019, but they didn't. And counsel's argument that the tolling provisions of these governor's orders should have somehow gave them another 85.
But those executive orders came after the lapse of the statute of limitations, according to your argument.
And also, Your Honor.
Correct?
Yes, and also, when you read 205, which they really didn't raise, because when you look at the argument that was being made, they never really raised 205. But 205 doesn't toll things, which is why those orders from the governor don't apply. 205 is really just an extension that gives you 6 more months to file.
Yes, but so 205A allows you an additional 6 months to refile, correct?
Right.
And according to your adversary, since that 6-month time period fell within the time period of the executive orders, that extended her time. Why is she incorrect?
Because she just made it up.
No, it doesn't make it up. So let's, if the pandemic had not happened,
right,
she would have had to bring the action, right, reinstituted within 6 months of the dismissal, correct?
Right.
Okay, but she wasn't able to do that because by then we were in the full throes of the pandemic.
However, 205, which they really didn't raise, but presuming they did, is not a statute of limitations or a tolling.
No, I understand.
That's what the executive
But that
order-
doesn't matter. So if she would have, but for the pandemic, had until sometime in early 2020 to file this complaint and wasn't able to because our courts weren't accepting any filings, and the court and the governor then issues these executive orders, why would that not apply to her?
Well, the court was accepting filings, and also because 205 is not a statute of
I
limitations.
understand that. You keep saying that, and I'm telling you, I get that.
Okay, good.
The fact that it's not a statute of limitations doesn't change my question.
You could have, the law says you have to file the action within 6 months of the dismissal.
Okay, so let's go to dates, Mr. Altman.
Okay, thank you, Your Honor.
Okay, so the dismissal without prejudice is in December 12th, 2009. The 6 months pursuant to 205A rather, was June 12th, 2020. The executive orders began in March of 2020. Am I correct?
I believe that the action was dismissed April 3rd, 2013. Statute of limitations expired in 2019.
Talking about
The action was-
Counsel, I need you to focus on her question.
I thought I was. I'm sorry.
The dismissal is in December of 2019.
Right.
Is it not?
Yes.
Okay, so June 12th, 2020 was the 6-month period pursuant to 205A. Then you've got the executive orders that told the statute of limitations until February 2021. The DJ application is filed March 2020. The second foreclosure action is filed November 4th, 2020. The numbers run counter to your argument.
As the court just said, the executive orders stayed the statute of limitations, but this is not a statute of limitations issue. That's what I'm saying. And
Right, but doesn't 205A serve, in essence, as a extension of the statute of limitations for these type of scenarios?
No, it's not a statute of limitations. All it simply does is give you, as the plaintiff, an additional 6 months to file your claim. And if you don't do it within
So that it is to file your claim.
Right.
So that it is considered timely. I mean, you can mince it whichever way you want, but at the end of the day, that's what it does.
Well, you could say, you can cut it any way you want to.
Right.
But the person that wrote CPLR section 205, which again, when counsel was asked at oral argument, do you have anything else to say about this, never raised 205. Never.
Okay.
So, but I'm saying, Your Honor, and again, it's brought out in Judge DeAugust's decision, which denied their motion to re-argue, and he details there is no.
But we're not going to go through that now because we're going to have to go through it again later. Okay, I'm sure. I've heard your arguments and we've got your papers. Thank you. You have time on rebuttal.
Thank you, Your Honor. We'll only have to go through it later.
Just to be clear about this, this action was started on March 12th, 2020.
That's
right?
correct, Your Honor.
And you started another foreclosure action on November 4th, 2020.
Correct.
And Supreme Court in this case did not reach the issue of statute of limitations because it otherwise dismissed your case, right? Because of the 2013.
I'm sorry, I lost you on the tail end of your question.
Let's just, the Supreme Court didn't really deal with the statute of limitation defenses in its decision, or did it?
Well, I think you're right. The court really didn't get into the limitations defenses as they pertain to the Article 15 proceeding. The court didn't get into anything having to do with the merits, with the affirmative claims, or the defenses, because the court separately.
So what you can hope for from us is that we restore the action and let you go back to Supreme Court and fight about this.
Exactly, Your Honor. That's exactly right. The court applied the limitations period in a totally separate action. Not this action. No one considered the limitations period for this action, much less the merits of the claims that they govern.
Okay.
The action was timely and will only be back
Oh, you will be back.
verse. So
Okay.
we respectfully request that you do that. Thank you, Your Honors.
Thank you so much. Have a good day, both of you. PJD Corporate versus Henry George School. You may
Good
proceed.
afternoon. Patrick Dwyer for Appellant PJD Corporate. This case is like some of the other cases today. It's on its second trip to this court. The prior trip to this court does not involve an issue that's before the court now. The initial decision was one of Justice Reed, who dismissed claims by PJD.
So your agreement with the defendant does not specify what your commission is going to be.
Correct.
Right? So if you were to prevail here that you should have a cause of action, how do you get to what the damages are? You haven't made a claim per se as to what they should be, have you?
We don't yet, because we have not had discovery of Douglas Elliman, the broker that absconded with the...
Let me ask you this. What do you claim your damages should be?
There's a number of cases out there that talk about sending this to special referees to determine how much the defaulted broker was put out for researching and doing work in order to get to the point where the grantor of the exclusive brokerage agreement absconded with the rights.
So are you making sort of like a quantum meruit argument?
Well, that's what some of the cases seem to be saying, that it's not specifically a percentage of the selling, or now in this case, the dual broker's fee, but it may be something else. And there's actually several...
How can that be in this circumstance where hold on, I want to make sure I got the entities right this time.
Elliman and Edinburgh.
Yeah, hold on. You were working on behalf of
HGS.
HGS. So under that agreement, you had to work out any commission sharing with the other party.
Correct.
Correct?
Yes.
So that there would not have been, in the typical instance of that, is it customary that a sharing broker is going to entertain discussion about whatever research you may have done for HGS prior to them coming to the table?
Probably not, but the damages come from the defaulting grantor of the exclusive brokerage agreement.
But why would the damage, the limits of the damage not be based on the sale price of whatever property?
That's entirely possible. Don't rule that out.
Why would it be anything but that, is my question.
It depends on how much work went into this before the point when...
When you say how much work went into this, into the actual transaction at issue?
We had nothing to do with that transaction.
So then why would anything else, any other work you did before, be on Douglas Elliman or certainly on Douglas Elliman?
The claim here is against HGS. It's not against Douglas Elliman. The claim is against HGS for simply abridging or aborting it.
I understand that part of it.
And it is possible that it's either something resembling quantum merit or a number that is based upon the amount of the brokerage fee that the actual broker that took on the case. So there's alternative possibilities there. We've not gotten anywhere near that because we never got discovery of Douglas Elliman.
But you're not saying you're entitled to a percentage of that brokerage to be paid by HGS.
That's exactly what we're saying. They're the ones who caused the damages.
Right, but you're not saying that HGS has to pay you a percentage of the brokerage Edinburgh paid Elliman.
Actually, we are.
You are.
We are. That's exactly what we're saying. And in this
But what
case,
you're not saying is that you are seeking to disgorge any of the fees that were paid to Elliman because you have no privity with Elliman. Element.
Element has already put itself in that position because it gave a hold harmless to HGS because they knew what they were doing was incorrect. They are now the real party in interest in terms of a loss here.
Okay.
But when you say you're entitled to a percentage of that brokerage, how does that work with the quantum merit idea?
I'm not saying we're going to get both. There's a continuum there between quantum merit and/or the percentage basis. This has been sent to referees several times, exactly on the same kind of event.
Okay. We'll hear you on rebuttal.
Good afternoon, Your Honors. Robert Angelillo, Solbach and Angelillo for defendant, respondent Henry George School and respondent Douglas Elliman. And just to clarify where the status of this case, Elliman was dismissed from his case in 2019. Edinburgh, the seller, was also dismissed in 2019. That was on motion to dismiss, 3211. On the appeal of that decision, this court determined that the nature of this agreement, whereby the only obligation that Henry George School had was to tell Edinburgh PJD was our broker. That's the alleged breach here by Henry George.
You also had to tell the broker that you were talking to another broker about a potential purchase. That's what exclusive broker means.
Right. Well, what happened here was, in the decision from this court determined that that agreement is unenforceable, or determined that, and I can read from this court's decision.
I have it. I was on that panel. I don't recall saying that.
Well, here's what Your Honor. So it says, while the failure to identify plaintiff as buyer's broker can be actionable, it is only actionable where plaintiff has some contractual or other entitlement to be paid once it is identified as the broker, citing to Lansco.
But if you continue, it says that there's no cause of action against the seller or its broker for the commission. It doesn't talk about the buyer. And here, unless I misunderstood your adversary, the target defendant is HGS.
Right.
Because the school entered into an agreement with the exclusive broker and said that a termination letter could end the relationship, but that it had to give notice. And it was, how much? 60 days notice. So what do you say about the language in the termination letter that said effective immediately? Doesn't that run counter to the agreement?
Your Honor, my response to that is once the agreement was determined to be unenforceable, then that provision doesn't apply.
But unenforceable as to who?
Yeah.
Unenforceable as to anyone. And the reason why...
Wait,
No, that's not what we said.
I'm going to explain.
That's not what the decision says.
But the lower court is what the...
Look, you just finished citing our decision, and now you want to go back to the lower court.
Well, I want to explain why your decision did not address Henry George School. That decision was made, as I said, after a motion to dismiss. Henry George School lost the motion to dismiss. In my experience, motions to dismiss, a denial of a motion to dismiss is generally not something that's going to be reversed. They didn't appeal. Douglas Elliman and Edinburgh appealed, and that's when this court...
Didn't you hear the part that I quoted, that said that the contract was not enforceable against the seller or the broker for the commission? The target here, as we were discussing, is the school. The school kept the exclusive broker's identity quiet, and therefore the exclusive broker did not have a chance to do anything to earn a commission, to negotiate with the seller, nada, zippo.
The school was not referenced because the school was not a party to that appeal. And the decision was, because there is no underlying contractual obligation, the claims for interference and aiding, abetting, and conspiracy against the other defendants were not actionable because there was no actionable underlying claim against the school, because there's no contractual obligation to pay.
You're in the caption. I don't understand. The case that we're talking about names Henry George School as the first defendant.
Correct, Your Honor. And then in the motion for summary judgment, upon the receipt of this court's decision, We move for summary judgment on that basis, and it's granted, and the Supreme Court determines the agreement unenforceable.
Counsel, I'm just wondering, if we are to accept your interpretation of things, even in light of what is clearly an order from this court that details our position, but if we were to accept your position, and the school never introduces their broker to the seller, which is required in that agreement, and they would never know about any other deal, how would they ever get paid? I'm just wondering.
Well, in this instance, what the court determined was,
That's not her question.
oh, okay,
We're having that a lot today, okay? We're lawyers too. We know what we're asking and when our questions aren't being answered.
well, if in fact, what the court is saying is, if in fact Henry George had told Edinburgh still had no obligation to pay, so there's no contractual obligation there. What the remedy to that is what's the other cases that are even cited by PJD, the underlying exclusive agreement has to have some mandatory language in it, which was missing from this agreement, which is why.
Well, then
Not
how?
what the case law says, counsel.
That's-
not what the case law says. The case law clearly says where someone has an exclusive broker and you don't provide them with the opportunity to negotiate, they can't get paid from the school. You made that agreement. So you can't also then cut off their capacity to be paid.
Your Honor, this court said that in this instance where there was no obligation to be paid, that the failure to notify Edinburgh did not.
But you cost them, had you told them they could have gone to Edinburgh, they could have gone to Elman, and they could have gone to Elman and said, look, we got a share of this, got to get a share of this commission because we're the seller's exclusive broker. So that's what you cost them.
Well, this court found that even if they had done it, there was no contractual obligation to be paid, and therefore there was no actionable cause of action. And the causes of action that were an issue on that appeal were the interference, aiding and abetting, conversion, et cetera, of the underlying claim, which the court found does not exist.
It's amazing. Everything you just said wasn't in this decision, but we will look at our own decision. Thank you.
Thank you, Your Honor.
What respondent is looking for is a carte blanche to allow the grantor of an exclusive brokerage agreement to simply walk away without any penalty ever.
Additionally, if I may,
Sure.
there was an email, January 2017, that said that the termination had nothing to do with performance and
Correct.
effort. We are opening up the search to all comers in order to accelerate our efforts.
I would
So
respectfully.
there was no wrongdoing here, any malfeasance, any lack of enterprise or ability.
And the record has the fact that they had looked at 33 separate properties to show them, and many of which they went to visit. If I could draw the court's attention to one last item, on page 260 on the record of appeal, this is an email from Andrew Mazzone, the then president of HGS, to George Vanderploeg, the broker who ultimately took the whole job, our motion to compel was denied by the lower court because it was no longer a case that was living. The last line of it is from Mazzone to Vanderploeg. Let's handle this. This is on January 12th, 4 days after the supposed immediate cancellation of the exclusive. Let's handle this so that it works for you, Andy. I'm sorry, I misread that. Let's handle this so this works for you, signed by Andy to George. Unfortunately, we never had that when the first motions came around. Thank you very much. If you have any other questions.
Thank you so much. $161 Ludlow Food versus LES Dwellers.
Good afternoon, Your Honors. May it please the court. My name is Michael Del Piano. I represent the appellants 161 Ludlow Food, LLC. On this appeal, there's a very narrow issue to determine, and that is what is the appropriate standard on summary judgment for affirmative claims for attorney's fees and punitive damages by SLAP defendants. In this case, the lower court erred when it applied CPLR Section 3212, subsection H, to grant partial summary judgment on the issues of liability for attorney's fees and punitive damages against 161 Ludlow. It's our position that 3212H only applies for motions of summary judgment that are against the principal SLAPP claim itself, not for affirmative counterclaims or any claim that might somehow relate to a SLAPP claim. It has to be against the actual SLAPP claim itself. There's no dispute that the principal SLAPP claim in this case was dismissed under 3211G by the court back in 2018, and that got affirmed by this court in 2019. 161 Ludlow has not pursued any claim against the respondents since the matter was dismissed other than to do that appeal. So there was no question that when the motion for partial summary judgment was made by the respondents that 161 Ludlow was not pursuing a SLAPP claim and that that motion was not directed towards a SLAPP claim. The express language in CPLR 3212H demonstrates exactly what 161 Ludlow is applying, and it says it applies where, quote, the action claim, cross-claim, or counterclaim subject to the motion is an action involving public petition and participation. That's clearly not what we have here. This court has said numerous times, including in Hariri, that because SLAPP is in derogation of the common law, there needs to be a narrow construction. It needs to be strictly construed. The lower court's application of 3212H on affirmative counterclaims gives SLAPP the broadest possible construction and said that 161 Ludlow had the burden of proof on the motion for summary judgment instead of appropriately with the respondents. It is a canon of statutory construction that when you're reading a statute that you have to give effect to all the different parts of the statute in order not to make any part meaningless or superfluous. The subject to the motion language in 3212H would be superfluous by the lower court's reading. And in addition to that, civil rights law section 70A would also be deemed superfluous as it relates to attorney's fees and punitive damages, which requires a demonstration on the part of the respondents, not on the part of 161 Ludlow, in order to demonstrate that summary judgment is appropriate. I see if there's no questions, I would like to reserve the rest of my time for rebuttal, please.
Okay. I'm saving 1:45, okay?
Good afternoon. May it please the court, Stuart Kagan on behalf of Appellee's Lower East Side dwellers and affiliated persons. We believe that the court's decision below was well-reasoned and should be affirmed. And we think that is so for three reasons. First of all, we think the statute is actually quite clear and properly interpreted and enforced by the trial court below. That just comes from the words of the statute. CPLR 3212H, which my friend referred to.
Are attorney's fees mandatory?
Now they are.
Were they then?
No, exactly not. They were not. Under civil rights law section 76A, as it existed at the time that this action was pending, attorney's fees were discretionary within the reasoned discretion of the trial judge below. Therefore, for example, I'll note.
What standard did the trial court below use to determine attorney's fees? Did they say mandatory? Did they say discretionary and then go through that analysis, or did neither happen? Was it just a statement?
So the trial court's decision, which is at the record at page 5, does not specifically state any standard by which the court decided or did not decide to award attorney's fees. But there is,
If we were to assume that it was discretionary, should it be sent back for that analysis to be made?
Respectfully, I think that that is unnecessary given the ample record that was given to the trial court to consider. And I think it was obvious, I believe, to the trial court to understand that the issue of attorney's fees was discretionary, Justice Pitt-Burke, because it was briefed to the trial court below. In fact, in the moving papers that were noted, the issue as to whether or not the attorney's fees was or was not mandatory was well briefed and fully in front of the judge, as well as the issue as to the fact that it was in the court's discretion to determine it. That, however, doesn't get to the issue of liability. The issue of liability.
Well, for us, it does in that we have to be sure that the court utilized the right standards. So is there anything in the record that you can point to that we can glean from it? I mean, I think you've already said something by saying that it was articulated directly in the paper so that the writings would have put the judge on notice. But is there anything that the judge said or in their writing that allows us to glean that the court understood that it was at that juncture a discretionary call of the court and not a mandatory one?
Yes, Your Honor. I believe that the answer as to that was within the papers that were filed for partial summary judgment that were filed by Lower East Side dwellers, the appellees below.
So the only place I can glean that from, the only place that I can assume the judge understood the standard is from the writings by...
The complete motion papers are very clear on it. And just to be clear on my point, the original briefing papers were to note that there was, in fact, a statutory interpretation question that was well briefed in the papers. And the argument that was made in the papers was, during the pendency of the motion, I apologize, this may take a time, I apologize.
It's okay, go ahead.
Thank you. During the pendency of the motion motion for partial summary judgment, New York State changed the statute. Okay. So when we made the motion, the fees were discretionary. And then afterwards, the statute was changed. A federal court decision came out and decided that the new statute should be retroactive and should run back and cover these claims, even though the claim was brought when the statute was discretionary. We made that argument based on that federal case. We said, Judge, it should be mandatory, which is not the law. I understand, but we had a reasoned, good faith belief that it was at the time. Based on this federal case, you should mandatorily award fees. We set all that out in our moving papers. In opposition papers, subsequent to the filing of our papers, we had no idea that this was new law. New law came forward from this court. This court held that that federal court's decision, which we cited, was in error with regard to New York law, which is, of course, this court's duty. And this court said, no, 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 the law stays as it was. It is not retroactive. Attorney's fees are discretionary. My friend, opposing counsel, brought that to the court's attention and referred to that case in detail before the court. That issue was clear. In reply, we discussed that issue in detail. And we said, we didn't make any mistake here, but you are the court that determines the law. We interpret it as best as we can. Now that the law is clear, we believe...
So this issue was fully before the court, and the court
did not
make the decision blind.
Absolutely not. And then on that basis, and the ample evidence that we put in, which, among many other things, dealt with spoliation and all the rest, the court awarded fees.
So your reply then before the motion court acknowledged that it was a discretionary standard in light of the legal developments?
Absolutely, Justice Hagan. Absolutely, and it's discussed at great length because we had the First Department's decision at that time.
Thank you.
If there are no further questions.
Okay. 1 second. Go ahead. I'm going to give you 15 extra seconds.
Thank you. I agree that Mr. Kagan on reply in his papers did address the fact that we had brought forward that it was still a discretionary standard. But in their initial opening papers for their motion for partial summary judgment, the respondents made no argument that any discretion had to be used.
But that's okay. Look, at the end of the day, from our perspective, the issue is whether the court heard all of these arguments so that we are clear that the court understood that it was discretionary.
Understood, okay. Right? But in the court's order to address the question that was asked prior to that to Mr. Kagan was about whether the court addressed it in its decision, and the court did not. The court applied attorney's fees and punitive damages, liability on both, because it said 161 Ludlow did not meet its burden under 3212H. It had no burden under 3212H. So the court did not apply a correct standard. The court treated the request for attorney's fees like it was mandatory if 161 Ludlow had not met a burden it did not have.
Okay.
If there are no other questions on that, I would stand on the brief
Thank you so much.
and request be reversed. Thank you.
All right. All right, next case. Tishman versus Himmel and Merengoff and City of New York. You may proceed.
Thank you. Good afternoon. May it please the court, I'm Sarah Mahoney, here on behalf of appellant Stephen Tishman. Your Honors, this case presents a fortunately rare and very specific factual scenario in which the City of New York specifically identified an immediate falling hazard for pedestrians, failed to take the steps required by the building code to ensure that that mortally dangerous hazard was abated.
What steps is the city supposed to take?
Your Honor, under Section Article 216 of the Unsafe Building Code of the Article 216 of the Building Code, the Unsafe Buildings section, the city is required to file an unsafe buildings report, participate and order a survey of the building, institute.
They issued a violation, didn't they?
Yes, Your Honor.
And what happened after that?
So after that, Your Honor, it's undisputed that the city deemed this an unsafe building by virtue of the findings at the April 29th, 2019 inspection. This was an unsafe building under the definition of Article 216 in the Building Code. So the city itself did have an affirmative duty under that section to not only force the building owners to fix this building, or at least put a sidewalk shed, which would have saved Erica Tishman's life, but the city itself also.
Isn't your argument really that, or wouldn't you, in order for that to work, wouldn't you have to argue that the plaintiff was some sort of special class? And do we have that here? I mean, she's a pedestrian like any other walking down the street.
Well, Your Honor, we say that the Article 216, specifically the unsafe buildings section of the building code, does have in mind a particular class, because it's not like, for example, the inspection section of the building code. It's a section that requires the Department of Buildings and the city to specifically and immediately address these dangerous conditions. And it's not so that it
Who's
helps.
the special class?
Well, so Your Honor, it's not so that it helps every single New Yorker, but rather the New Yorkers who are specifically exposed to that particular danger.
And who were those New Yorkers? Who is that? Anyone who's walking on that street? Anyone who lives on that block? How is that special?
Well, Your Honor, I would say that in this case, the building inspector himself identified the particular class by, in the violation itself, saying that this was an immediate falling hazard for pedestrians.
So any pedestrian?
Near this dangerous condition, yes, Your Honor.
So I will tell you very frankly that the special duty exception has always been troubling to me. But that doesn't get around what the case law says. And I'm thinking of a 1983 Court of Appeals case, Worth Distributors versus Latham, where it says that administrative code provisions relating to building safety were designed to protect the general public. No special relationship is shown that would establish a municipal duty to plaintiffs in particular in that case, even where the Department of Building employees knew of the dangerous structural condition of the building. And I unfortunately see an analogy with this situation. We can't get around the fact that this was a tragedy. The special duty exception is just long-standing. Can we get around it?
Well, Your Honor, I believe we can in this case. I would like to say I believe the Worth case is distinguishable, because in the Worth case, the city did not issue a violation for the particular condition that ultimately caused the partial building collapse. And there's also the situation of positive direction and control in this case. So the positive direction and control cases, like the ones we cite in our briefs, Glittman, Smullen, Ferreira, they're very factually specific cases. And interestingly, they're very different from one another. None of them are alike. But there is a through line for all those positive direction and control cases. And the through line is that there was a moment in time when the city had an opportunity and the ability and the authority to fix or abate or stop or ameliorate a known, ongoing, dangerous condition.
Isn't that, go ahead.
Please.
Isn't that true of so many hazards and defects and dangerous conditions throughout the city, though?
Your Honor, I do
Like
believe...
lead paint abatement, for instance?
Well, so I do believe that this is a specific category of cases because, again, we have the building inspector himself saying that this is a falling hazard for pedestrians.
But that's the same as Worth. And then if you look at Applewhite, which is Court of Appeals as well, Court of Appeals says that as a general rule, the government is subject to ordinary tort liability if it negligently provides a service that would ordinarily be provided by the private sector. But with respect to the issuance of building permits or certificates of occupancy, for example, those are long recognized examples of quintessential government functions. And here, the inspection of the facade is a quintessential New York City governmental function. Would you agree?
Yes, Your Honor, I agree that inspections fall under that category.
But
as
inspections
does-
and the follow-ups, we have thousands of buildings in New York City. We don't have thousands of inspectors, right? And we know that, which is why the case law has come out the way that there is no way for the city to be able to keep up with the check every building for which you have issued a violation every 60 days. Perhaps they need to revisit their rules or create some other way of verifying completion of work. But the case law is what it is, and we have a lot of it on these governmental function cases.
Your Honor, if I may, so again, I would draw the court's attention back to positive direction and control, because I do understand what you're saying, but at the oath hearing, the city had an opportunity. That was the city's opportunity to demand immediate compliance or to tell this building owner to just immediately put up a sidewalk shed to protect pedestrians. Or the city could have done it itself and billed the building owner, which the city is empowered to do under the building code. This is a situation where the city showed up to an oath hearing 5 months after its city inspector, effectively said in his own citation, wow, this could kill people. And the city at this oath hearing knew that the building owner had done absolutely nothing about it. And the city had an opportunity to do something in that moment.
And the city reduced the violation from a Class 1 to a Class 2.
Yes, Your Honor. And put it back into the hands of the already demonstrably non-compliant building owners.
Thank you.
Thank you.
May it please the court. Deborah Brenner for the city. As the court has already pointed out, there is no particularized class here under binding Court of Appeals precedent, as is necessary to give rise to an implied statutory special duty, an implied statutory private right of action. But in addition to the pedestrians not being a particularized class, there are also two other reasons why that doesn't work. One is that this statute already has a very exhaustive panoply of penalties. They all are laid out, most of them are laid out seriatim. And as the plaintiffs have effectively conceded, none of them authorize a suit against the city. What they authorize is that for the city to bring suits against private owners and managers of buildings. And that, as the Court of Appeals said—
that really, I gotta tell you, that argument gives no solace to this family, right? Because
understand that, Your Honor.
had the city done their job, had the city taken the time to not giving this building owner a slap on the hand, maybe this woman would be alive today. So you may not be liable, But the city certainly bears some responsibility for the happening here.
I'm
because-
not
right?
here to even dispute that, Your Honor, although I would point out that even the reduced violation directed correction within 60 days, and the
And did the
accident
city
happened-
follow up and see if 60 days later they did anything
The record-
before
the
this
record is
brick
silent
fell
about
on
that.
this woman and killed her?
Your Honor, it's, as most New Yorkers would probably tell you, it's one of my own fears about walking through the streets of the city. But what we have is a very developed body of law here that says, and you know, the plaintiff does have a suit that's still active against the building owners and the building managers, which will continue regardless.
What about the third aspect? Because we've focused, I think, on the first form of special duty under Ferrer and the cases that preceded it. What about the third path to a special duty, the positive control? This isn't the normal case of just nonfeasance. There was involvement here by the city, and they did take some actions with respect to the subject property. So would you mind addressing that third aspect, the positive direction and control?
Absolutely, Your Honor, although I'm not sure I agree with your premise. I don't think what the city here was to take an active role, because all of its actions were merely regulatory, even the reduction. Let's be clear, the plaintiff has conceded that the only place that the city could have conceivably, the only argument that they're raising is at the oath hearing that the city took positive direction and control.
Are you
When
saying
the-
that her argument that the city could have put up a sidewalk shed or ordered a sidewalk shed be put up is not an accurate statement?
No, it's not that it's not an accurate statement. It's that the city did have the authority to do that. But by doing that, that's how the city would have perhaps taken positive direction and control. They are conceding and in fact charging that the city didn't take those actions, which is, you know, then how did we actually
No,
take
but your
positive-
action was to
Yes.
give them a slap on the hand and let them self-correct when they hadn't self-corrected in 5 months.
Your Honor, let me be clear. We're not saying that there was no duty here. The complaint alleges many duties on the part of the city as well as the private parties. But the Court of Appeals has made clear that it's not the kind of duty that can support a negligence claim. It's just not.
So what is the appropriate standard for, I know there aren't many cases, I'm not aware of many cases on dealing with that positive direction and
Right.
control. What is your understanding of the standard for when a special duty will arise under that?
Of the three species of special duties, it is the one that is by far the least developed, notwithstanding the Ferreira case that recently came down. Before I turn to that question, I just want to point out very quickly that this argument is really foreclosed as a matter of law because there's nothing about the oath hearing in the notice of claim, and that precluded the city from even considering whether a special duty had been formed. This court said in Perez, a notice of claim needs to have the factual predicate for any special duty, which if that's what they're pointing to, and that is all they're pointing to.
Frustration here, counsel, is that there's no way of holding the city accountable for these kinds of things, for the nonfeasance.
Your Honor,
It really
that's-
is.
that's-
You have a Class 1 violation slapped on the building in April of 2019, another violation for failure to correct in July of 2019. You have the oath hearing in September of 2019, where the violation is reduced, am I right?
Yes.
The violation is subsequently.
From Class 1 to Class
Yeah,
2.
Yeah, and then you have a $1,250 fine, and this lady dies. This lady dies like within months of the oath hearing.
Correct,
The
Your
same
Honor.
year.
It's terrible.
Within 6 months.
Did you make an argument that the notice of claim did not include anything about the oath hearing?
Yes, Your Honor, that's in our
Did
brief.
you just say that the oath hearing happened after?
Happened after what?
The oath hearing occurs prior to the notice of claim?
Yes,
Okay. All right.
I believe that's correct. Yes, because the oath hearing happened prior to the
Just the
accident,
way
and
that
the
you were,
accident
the
happened.
way you were saying it seemed like it came after.
Oh,
So
no.
like, how could
If
it
I
be
said
in
that,
there?
I apologize.
That's why I was confused. I was like, wait a minute.
If I said that, I
Okay.
apologize. But I do want to get back to your question about the exception. And also to address the fact that, like, all of these are exceptions. They are narrowly carved. They're intended to be narrowly carved to serve the purpose of special duty doctrine, which is to keep the city from being faced with you know, a crippling potential burden in such a way that it would wind up making the citizens and denizens of the city less safe
So what
rather than
exposed
safer.
the city of Binghamton to liability under the positive direction and control theory? But the city of New York is not exposed similarly to that type of liability under positive
You're
direction.
talking about Ferrara?
Yep.
The Ferrara case? Because in the Ferrara case, the police officers actually entered the premises and they really took control. They detained the potential class of plaintiffs and shot one of them. Here, the city's acts were far temporally and spatially removed, except for the inspector, who they're not saying took positive direction and control, right? They're saying that this DOB attorney at a hearing months before the accident ever happened, never having visited the site, just by saying, well, we don't think our evidence, we agree with the building that our evidence isn't enough to support class 1, but we still think it's dangerous enough that, you know, just by these photos that she's looking at, we're going to reduce it to a class 2. In no way is that similar or analogous to police officers bursting over the threshold of a residence. I mean, you know, and saying nobody move. That's, you know, if the city had done something like told the building owners, don't do anything to this this hazardous condition until we say you can, then you might have positive direction and control, though I'm not sure it would extend to this
You
plaintiff.
say the oath hearing took place after the plaintiff passed away?
No.
It's not.
No, the oath hearing happened 90 days, about 90 days before the accident, before the plaintiff's accident. And just to point out that the O'Connor case refused to find, in addition to finding no statutory duty, special duty, also found no positive direction and control by observing, first of all, that the city had not authorized or even acquiesced in what the building owner had done that caused the accident. Second of all, that it happened 9 days later when the building inspector was no longer present on the scene. And third of all, that even that tenuous connection between the building owner and the building inspector was absent for the other parties who were also plaintiffs, who were injured in the explosion. So what that tells us, although it's not spelled out anywhere in the case law, but many courts have made clear that there has to be a connection of some kind, even if it's not as stringent as the voluntary assumption where you have that 4-part test of, you know.
Let's not go through that,
Right,
because
okay.
you are about
Yes, but
7 minutes beyond your time.
Okay, I'm sorry. It just, will the court give me permission to just say?
No, we're done.
Okay.
Thank you.
Thank you.
2 minutes on rebuttal.
Your Honors, the Court of Appeals has found that special duty does arise in some specific types of cases based on the city's particular acts or omissions, for example, in the Ferrara case. We submit to you that this is such a case. Indeed, Your Honors, if not this case, what case?
But isn't there, as your friend pointed out, a significant spatial and temporal difference from, or attenuation here from what happened in the oath room and then the accident? Whereas in Ferrara, the officers were the one who broke down the door and shot the innocent party. There's an immediate temporal and spatial connection, whereas here is that lacking?
Well, Your Honor, I don't read the cases as requiring that element. I haven't seen any case that does require that element. And, you know, there's another case that we cite in our brief. It's a Court of Claims case, Glitman. That's the one in which the state troopers stopped an intoxicated man, helped him get gas because his car was out of gas, then let him get back on the road, and then he hit and killed a woman. So that's an example of yet another situation where the city, or in that case, the state trooper, there was a moment in time where those state troopers had an opportunity to prevent this dangerous condition. And you know, the state troopers obviously weren't with him when the actual accident occurred, and the plaintiff in that case obviously had no idea that the state troopers had done that, so there was no connection in that way as well. Your Honors, Erica Tishman in this case lost her life because the city knowingly and affirmatively allowed her to be exposed to this fatal falling hazard. Again, this is a case in which positive direction and control can be found because the cases are all very factually specific and not similar to one another, but this is a case where the city had an opportunity to do something and instead reduce this class violation and let this mortally dangerous condition go unabated. Thank you.
Thank you. People versus Anderson Worrell. And you have 6 minutes.
Good afternoon, and may it please the court. I'm Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Mr. Anderson Worrell. Anderson Worrell, who is about to turn 78, is never going to re-enter the New York community. Yet we're here today talking about what risk level adjudication he should have gotten for a scheme that is never going to apply to him. The SORA statute simply does not contemplate this scenario, assigning a risk level before an offender like Mr. Worrell is actually being released into the community. And because of that, this SORA hearing was premature. And the reasons for that are plentiful, and I'd like to walk the court through them if I may, beginning with the plain text of
Is there anything that would permit, under the text of the statute, that would permit the normal proceedings to go forward because of his change of custody to another jurisdiction? Is there anything in the statute that speaks to that or contemplated that and how to treat that?
So just to make sure I understand the question correctly, Your Honor, the question is if someone in general in New York State moves to another state, what does the statute do with respect?
No, like the scenario here is that his custody is being transferred from our New York State correctional system to Maryland, correct? Yes. And so the argument is that since he's going to another correctional facility, he's not being released.
Right.
Right? There's no need for this SORA adjudication process. Is that basically your argument?
That is, Your Honor, but I want to clarify, it's not that there's no need for it ever. The hearing has to happen at some point. It's a matter of when. So the argument is it was premature as applied at this stage when he's about to be transferred, as opposed to if he, and he won't be because he's serving a life sentence, but if he theoretically ever is actually released into the New York community. Right. And so the scenario where it's contemplated that he would end up having the hearing, upon this incredibly theoretical release, is covered by the correction law under 168K, which deals with individuals who have been convicted of sex offenses in other states. So under that part of the statute, a person who's been convicted of an offense in another state, if they change their residence to New York, has to submit to the New York Division of Criminal Justice Services in 10 days, or they've committed a felony.
So there's nothing specific as to this particular scenario?
Yes, sorry, I understand your question better now, I apologize. Okay. That's exactly right. There's nothing.
So let me just ask this question. He's going to another correctional facility, and he's not the first person that will happen to. He's not the last. This particular defendant, however, is going to be serving a life sentence. He'll never be out. But if we were to adopt your position, for those people who were transferred from New York correctional facilities to other state correctional facilities, and then maybe not returned by that correctional facility to have their SORA hearing, where does that leave us?
So in the scenario you're contemplating, Your Honor, is that person who's transferred out of state returning to New York or staying in the other state? Either.
But that's the question, right? So once, it seems to me that to ask the New York courts to depend on sister jurisdictions, to not forget that, oh, by the way, when you release him, we still have something with him. He needs to proceed to this hearing before you let him out. Why do we have to wait for that and risk that doesn't happen? And we know mistakes happen. Prisoners get released all the time when they shouldn't be, right? So why should we not, what impediment is there to proceeding with the process as is statutorily prescribed?
Well, first of all, hearing prior to a transfer is not statutorily prescribed according to our interpretation.
Well, he's being released from New York custody. So a SORA hearing upon release from New York custody is prescribed.
So a couple of things. I want to address the first point that Your Honor made. So the scenario where a person leaves a New York jurisdiction without having had their SORA hearing yet, doesn't mean that they're not on a list that belongs to the New York Division of Criminal Justice Services. As soon as someone is a convicted sex offender, they are a certified sex offender in the state of New York. There's no scenario where this person is not, again, maintained in a register in a file of individuals in the Division of Criminal Justice Services that is monitoring
Right, but
these
there has to be a hearing to classify them once they're released from correctional facility.
Yes, there has to be a risk level adjudication, but that is distinct from whether the person is certified as a sex offender. So I just want to make clear that that happens no matter what.
Okay.
In terms of what happens when someone transfers to another facility, if he were to return to the state of New York, the statute contemplates that that person has to submit themselves to the Division of Criminal Justice Services. Now, I can't speak to why the legislature, in writing that section of the statute, didn't put a burden on law enforcement to keep track of people before they submit themselves, but that's what the statute says. So it was contemplated by the legislature in that section of the statute that if someone moves and establishes a residence in New York and has a sex offense in their criminal history, that they have to submit themselves to the
So
Division of Criminal Justice.
how does People v. Staley factor in?
Yeah, so we are asking the court to revisit People v. Staley, and I appreciate that a couple members of this panel decided that case. But there are a couple of reasons why we're asking the court to do that. First of all, that opinion didn't have the opportunity to address a lot of the statutory canons that we've raised in our briefing here. The underlying briefing in that case only looked at the plain text issue. It didn't talk about the absurdity canon, a constitutional avoidance canon, a whole host of other issues that we've raised. And also, there are 3 SORA cases pending, as the prosecution noted, before the Court of Appeals right now, not dealing with this exact issue, but dealing with this open question of when does a SORA hearing attach when someone continues to be confined in some way. And so, you know,
Is that particular issue being up before the Court of Appeals?
So the issue at the Court of Appeals deals with civil confinement, and so that particular issue interacts with another statute that pertains to civil confinement, but it speaks to the fact that there's an open issue in this statute. And I would suggest, you know, if the court is, you know, we're certainly not in a rush here, if the court is interested in waiting for the Court of Appeals to decide those cases before returning to this issue, because it might inform the best approach going forward.
What's the name of those cases?
You know what, I don't have them in front of me, I can tell you on rebuttal and find
Were those the ones that were argued a week or 2 ago?
in the Court of Appeals. I think they're calendared for January.
Oh, they're, okay, they haven't been argued.
All right. So you let us know on rebuttal. Okay. And you asked for 4 minutes.
Good afternoon, Your Honors. Christian Rose for the people. The SORA court correctly applied the plain text of SORA to find that the defendant had to be assigned a risk level before his release from New York custody. This court resolved this issue over a decade ago in Staley. The defendant offers no good reasons why this court needs to revisit that decision. I'll just quickly clarify that, for my friend on the other side, that the 3 pending cases are Boone, Cotto, and Dufresne. I believe they're all first.
Hold on, slow down. Say again?
Sorry, Boone, B-O-O-N-E, Cotto, C-O-T-T-O, and Dufresne, or D-U-F-R-E-S-N-E. And those are calendared, well, Dufresne is on SSM track, but it will likely be decided with the other 2, which are calendared for January 10th. So, but I don't think that this...
10.
Oh, thank you.
Yes. I don't think that this court needs to wait until those cases are decided to make this decision sometime in February or March. It's not clear whether those cases will address this actual issue. And I think that it's a straightforward enough path for this court to apply Staley to this situation. Second, the SORA court providently exercised discretion when it upwardly departed to risk level 3. The defendant brutally raped a young woman with a knife to her throat, absconded for decades, committed other sexual assaults in multiple states during that time, and was only caught when he was trying to purchase a firearm in Georgia. In short, this court should affirm the SORA's order, and if there are no other questions, we ask that Your Honors affirm.
Okay, thank you.
Well, I appreciate the assist from my adversary in answering that question for you. So I'll use my remaining time just to point out a couple other issues with the statute as applied here. I first want to, get a little bit into the purpose here. The goal here is to protect New Yorkers from people who will become their neighbors who could, commit a new offense, who have a high or any risk of reoffense. And holding a SORA hearing prematurely doesn't help the public in that way because it doesn't give them an up-to-date risk level. So say, for instance, that Mr.
So let me ask you this question. I guess just following your line of reasoning, when someone is released from a correctional facility in New York and they say, hey, guess what, guys, I'm out of here. I don't want to stay in New York State anymore. They're not going to be here in New York, so then why assign them a risk level? Why?
Well, in that scenario, they're actually being released into New York, Your Honor. And the distinction here is that Mr. Worrell was never released into New York. He's been transferred this month, or last month. He was put on another corrections bus. I'm not even sure if he changed handcuffs and sent to Maryland. I mean, that is not the same thing as a release when someone actually exits a correctional facility and enters a community, and that's really what the statute contemplates. This doesn't open up a sort of parade of horribles of any time somebody
But
says,
in the event that he came back to New York, this does have the ruling on the record, and if there's something untoward about it as to him, he can certainly move for reconsideration.
And you're allowed to do that once a year.
The
I understand all of your arguments. My question is, what is the harm in having this adjudication done now? Again, because from my perspective, it is not likely that this defendant will be released. I get that. But as my colleague pointed out earlier, I'm concerned about the case where someone gets transferred somewhere else and they only have a year over there. And that one falls through the cracks. And then we have someone out in the open who hasn't been assessed, right? So why should the court take that risk here?
well, first, it would contravene the statute, so that's sort of the first, point. But in terms of
I don't, not necessarily, I mean, the plain text of the statute says when he's out of New York State custody, and he is out of New York State custody.
the plain text of the statute, Your Honor, if read that way, is actually the one that opens this up to a floodgate issue of hearings, because if you read, release from any correctional facility to mean anytime someone is released from a correctional facility, then we would have to hold SORA hearings anytime an individual prisoner is transferred from Attica to Elmira, because they would technically be released.
No, but
from
that's
that
within the
correctional facility.
state, right?
Sorry?
That's within the state.
But that's not what if the plain text of the statute, if read that way, Your Honor, says any correctional facility. Read that way, it means any correctional facility. The argument we're making is that release is the operative word here, and release is not synonymous with transfer. And if I just make it briefly
Yeah, go
clear,
ahead.
thank you. I know it's been a long day, and we're all eager to get out of here.
And you got one more group waiting behind you. Go ahead.
I think the idea here that this is going to open the floodgates to all kinds of people slipping through the cracks is addressed, one, by Section 168K, which does have a mechanism for people who are out of state re-entering and establishing residence in the state, and also addressed by the host of other obligations that sister jurisdictions do have with us. This is a very specific set of circumstances. It's not likely to arise in a lot of other cases. And what we're advocating for here is really the least strained interpretation of the statute that, if anything, will allow a unit that is dealing with 40,000 registrants to best use their resources in the way that will actually protect New Yorkers from people who are in their midst, as opposed to someone like Mr. Worrell, who is, in all likelihood, going to die in a Maryland prison. So that's really what we're talking about here, is what is the best way to effectuate the purpose. And it's not one where an octogenarian is having a SORA hearing before he goes to Maryland. Thank you.
Thank you. All right. Last but not least, Figueroa versus City of New York.
I apologize for my cough in advance.
No problem. We all get sick in this time. You go ahead.
Good afternoon, Your Honors. May it please the Court, Gabriela Scarmato from Wade Clark Mulcahy on behalf of Defendant Appellant Bobo Realty Corporation. This is a simple trip and fall on a curb case for which my client, as the adjacent property owner, is not liable under New York City Administrative Code, Section -7.
Why isn't this an issue of fact?
It's not an issue of fact because plaintiff testified on numerous occasions that she tripped and fell on metal or iron. She stated some kind of metal caused me to fall.
She repeatedly said sidewalk.
She did.
Right?
She did.
And there was attempts during I believe the EBT to get her to say curb, and what do you mean curb? She wanted to know exactly what you meant by curb, and not you, I mean,
yes,
whoever was doing the EBT. And she stuck to her story that it was on the sidewalk. So why is that not an issue of fact?
Well, respectfully, she did not stick to her testimony that it was on a sidewalk. She did not understand what a curb was, and efforts to clarify that did not go over well. But if you look at the
Is this
photo,
the operative picture?
correct, photograph number 2.
So what's circled on the bottom, that's supposed to be what the plaintiff indicated is the place where she fell?
Correct, but that goes against her
So what
testimony.
does that count for? Does that count as sidewalk or curb?
That respectfully, I think where she circled is immaterial because it goes against what she said adamantly and on multiple occasions, I tripped on metal. Though she stated sidewalk, she admitted, I don't understand what a curb is, but she described what is shown in that photograph as the curb.
Well, as it turns out, oh, go ahead.
Please.
As it turns out, her understanding of the word "quote-unquote" curb may not have been important because it's a term of art under the sidewalk law, right? It's actually defined in the code. So even a layperson's understanding of the word curb might not comport with how it's defined by the city council.
Correct, but the fact remains that the description that she gave still was describing the curb. The curb slopes down. She said there was a missing area of sidewalk, but there is no missing area of the sidewalk in that photograph.
So, counsel, I'm looking at the photograph. I'm looking at record page 420, and here the photograph shows a defective curb that's missing. I also see a piece of sidewalk that's broken, that is in the shape of perhaps a rectangle, and I'm not sure whether the grate is elevated or not.
So
you ostensibly can fall on the sidewalk because of the curb and irrespective of the curb. You're asking us to decide as a matter of law that the plaintiff fell in a certain way, aren't you?
No, because that photograph that you're pointing to was an incorrect photograph that was used as part of her 50H testimony.
Sorry, this is an
That's not
incorrect
correct. That is,
photograph?
there was a belief that that's why the transit authority was in this case originally, a belief that she may have tripped on the grate, and she admitted that that is not the photograph of where she fell. The record page
I'm looking
418.
at 418.
Correct.
where
Number
it's-
2. That was taken moments after she fell.
And you're saying that 418 does not reflect the sidewalk in 420? It's not the same place?
No, it is. No, there are two intersections, one on one side, which is where she fell, and another one from a different angle, both having a crosswalk. So 418 was taken moments after she fell. It shows only metal on the curb. There is absolutely no metal on the sidewalk. The sidewalk was repaired 3 months prior to her accident. It was inspected by the Department of Buildings. It said that the sidewalk was flush. There's no evidence, no testimony that the sidewalk was raised. There's no cracks. There's no broken area of the sidewalk, though she says the sidewalk was broken, missing a depressed piece. All descriptive
Why
of the
isn't
curb.
that enough on summary judgment?
What is
It
that?
almost, the plaintiff's testimony to that effect, so there's no photos or documentation corroborating her account, but then doesn't that put us in the position of engaging in a credibility assessment, which is normally foreclosed on summary judgment?
Well, we do have a photograph here. Her testimony is clear, multiple occasions, I tripped on metal. There is no metal on the sidewalk. She didn't say my foot
Well,
hit two places.
she did describe it as kind of metal that would be, as I read it, it seemed like it was either rebar underneath cement, or that it may have been a metal piece either from a grate or that circled from the curb into the sidewalk. I couldn't tell.
Well, she said in her 50H testimony it was not the grate. She said that it was metal that was in the ground, embedded in the ground. The only metal is between the street and the curb. There is no metal touching the sidewalk, and the expansion joint touching the sidewalk, no metal. There can be no issue with fact that this happened on the curb.
You say that, but she keeps saying sidewalk.
Yeah.
So again, when we have a plaintiff who says, no, I know I fell on a sidewalk, she never changed that.
She did not change the word, but if you look at the overall description that she gave of sidewalk.
But again, isn't that a credibility determination?
I don't
We're
believe
saying,
so.
you obviously don't know what you're talking about. You didn't fall on a sidewalk, you fell on a curb. That's what you want us to say.
No, I respectfully disagree. The photograph is clear. There is no way her description of the sidewalk can match what is shown in that photograph.
She's laying on top of the sidewalk, right?
Correct, but there's no
So how can I tell what's underneath her leg?
But she said that she took a step and it was on the curb and was on the sidewalk. There's even the circle that she made on the photograph depicts that it happened close to the curb. There's no way she could have stepped onto the sidewalk.
Why?
She had testified in her first 50H hearing that I took 3 steps onto the sidewalk. That testimony was never made again in her second 50H hearing. It was never made during her deposition testimony. She continuously stated, metal touched my foot, I struck metal. There is no metal on the sidewalk whatsoever.
Okay.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is David Weissman for the respondent here. I mean, honestly, this panel has said most of what I was prepared to say in rebuttal, for the most part. The appellant here is asking the court basically to choose an interpretation of the evidence, which is not the court's function on summary judgment. It's that would be fact finding and not issue finding. So it's just not the appropriate role for the court here. And
Presumably a metal, if it's a rebar, if it's a grate, that's not a transient condition. So it's something that would be, generally speaking, fixed in the ground. I mean, metal could be transient, but the way it was described, it was something in the pavement, in the cement. Yet it's not depicted in any of the pictures, at least not in the area where...
the testimony is that the pictures were unclear. There was, if you look at you see in the 50, both in the 50H, I think, and in the deposition testimony, even defense counsel admitted that the pictures were not that clear, and this creates a credibility issue. I mean, the truth is that as I was examining the evidence and put in my opposition, I mean, it appears to me that at least there's another interpretation of the evidence that, and really, I mean, generally in this practice, where the plaintiff circles is generally, that really speaks 1,000 words generally. In other words, she made the circle in that spot. The assumption would be that's where she fell. But at the same time, the line and the section, which appears maybe possibly as an expansion joint, but she seems to be testifying that there was a piece of metal there, and that's within this spot. This is where I fell. But either way, that's also, again, an interpretation of the evidence. There's various interpretations, which were left up to a jury to decide. And certainly, I mean, she said sidewalk so many times. And to tell the court, basically, to try to insist and ask the court to interpret sidewalk as curb, just because she didn't know the meaning of curb, but that doesn't eliminate the possibility that it was sidewalk. I mean, it's just too far. And the same thing with the photograph. And basically what defendant asserts in their papers is that we have to look at the photograph, we have to look at the fact that she said iron. By the way, they don't have any personal admissible evidence that the iron was in the curb. Where is it? Where is the expert testimony about that? Where's the surveyor? Where's anything? There's nothing. There's just an assumption. That's insufficient. They didn't make their burden. I mean, she says there was a piece of metal there. True, usually that's the place for an expansion joint. It could be interpreted that there's a piece of metal where the expansion joint was. It's possible that no, a jury will say no, she must have meant actually the curb and there's no duty here. But that's for a jury to decide, not for the court. And again, basically, appellant is it's just one interpretation. One interpretation is insufficient.
I think
for
we
summary
got it,
judgment.
and we're way over. You asked for 2 minutes, and I gave you 4. You have 1 minute.
Thank you. I just want to point out that respondent put in his papers the case of Lanhan versus the City of New York, notably a Second Department case. But in that case, the plaintiff used the word interchangeably curb and sidewalk, and the court denied summary judgment because the defendant failed to offer evidence that the defect was solely on the curb. Here, that is distinguishable because the photograph is clear. I never said that it was not. The photograph is clear. It shows that there is no metal on the sidewalk. The sidewalk was repaired 3 months prior. The Department of Building said that it was flush. It said that the expansion joints were sealed 3 months prior. There's no cracks. There's no depressed area of the sidewalk whatsoever. The metal shows it's on the curb. Plaintiff was consistent with her testimony. My foot hit the metal.
And as your adversary said, is there evidence in the record about this metal on the curb?
We submit that it's in the photograph clear as day. You see the metal on the curb. You see no metal on the sidewalk.
Okay.
Thank you.
What happened?